Hello, everyone, and welcome to Uncivil Law. And I hope you are having just the greatest of days. And we are here with our continuing coverage of the Amyiah Cohoon story from Wisconsin. As we last left the action, our teenage heroine was silenced by a sheriff who came to her door and demanded an Instagram post be taken down that said that she had contracted COVID. And the post was taken down, and Amyiah didn't have a copy of the screenshot. She didn't have a copy of the Instagram, but we do. It is now our thumbnail on this channel. How very exciting. We have the original on it, so we now have the thumbnail that she posted that started the whole thing. So in case you want to know what actually started this whole mess, we now know. We have the actual thumbnail. How very exciting, because we're just that cool here on Uncivil Law. And for today, we have a response from the sheriff. Not one, not two, but three, count them, documents from the sheriff today that is detailing their response, including a sworn affidavit. Ooh, very exciting. So we're going to hear testimony in the form of an affidavit from the sheriff telling us what really happened. This should be good. And we're just going to cover this stuff and see what it has to say. It should be very entertaining for all of us. All right, so let's just get started. Oh, man, let's just get started. Tell you what, let's get started with, we'll just start here. It doesn't matter. We'll do them in any order. Oh, and for your viewing pleasure, upon recommendation of someone on the channel, you may notice now the background is slightly less white. So now it's less blinding. We've gone with a cream background for documents. Ooh, so it'll be a little less blinding, a little easier on the eyes. So I do take feedback, just be it noted. But let's read this and see what the sheriff has to say. Mr. Clump. What does Mr. Clump have to teach us? All right. The defendants, the sheriff, and the sergeant, by and through their attorneys, hereby submit this brief in support of defendant's motion for summary judgment. Now, the sheriff and his team have submitted several affidavits, not just from the sheriff, from other supporting characters, like the school nurse and some other random other people who went on the trip and such. So there are other affidavits that have been attached, but we're not going to cover those now because, one, we don't have time, and two, I get to use it in another stream another day. Very exciting. But they're moving for summary judgment. So basically they say we have established all the facts, there are no facts, or we have already produced all the facts, so we can just go straight to judgment, right? And this is a bold move. And a little unexpected. I would have expected the sheriff to, hide and cower and hide behind process for a long time. But no, they're going the other way. They've decided to go boldly into the night. They've attached a whole bunch of affidavits, and they say, we have what they say, we have their testimony and their affidavit, we have our testimony and our affidavit, and we're ready to go straight to judgment. We can win on judgment. We can win on the combined stuff. We don't have to do any discovery. Here's all the stuff. You have enough to render a decision. So it'll be interesting to see if Amyiah comes back and agrees that this is right for summary judgment or not. Because I'm not exactly sure what the immediate response here is. Obviously you can say, well, we'd like to have some sort of depositions where we could actually do some sort of questions from the lawyer and actually solicit things. So there's grounds to not do this, but I'm not sure what the obvious answer is in terms of, does Amyiah say yes, summary judgment, or no, summary judgment, we want more? I don't know. We'll see if we can see if we can do it. But they say we want summary judgment. We're ready to go straight to verdict. Very exciting. All right. The plaintiff, Amyiah Cohoon, files this lawsuit alleging retaliation in violation of the First Amendment. While the plaintiff was not arrested, the plaintiff claims she was threatened with arrest, and therefore postures her claims as retaliatory arrest claim. Also, the fact that she was deprived of her fundamental right to speak, and she was threatened. So there's that. To establish her First Amendment retaliation claim, the plaintiff must establish the following. They engaged in protected speech. The over's actions caused the plaintiff to suffer an injury that would likely chill a person of ordinary firmness from continuing the activity. For example, do this or I'm going to arrest you or something to that effect would be it. And the First Amendment activity was a motivating factor in the adverse action, which, as the plaintiff pointed out, it appears to be the only factor. So, like, we don't have to get into that mixed motives question. It appears to be the only factor. So we'll see what the sheriff says if one of these three things doesn't apply. Let's find out which one of them the sheriff doesn't think applies. In light of the Supreme Court's recent ruling in Nevins, in cases alleging retaliation in the form of arrest and presumably alleged threatened arrest, the existence of probable cause is usually a bar to a claim. That's true. There was a Supreme Court case on this point which dealt with motives and mixed motives, and the Supreme Court said essentially in so many words that as long as they have probable cause, it's probably okay. And this also applies, incidentally, not that it's really on point, but I might as well teach you something while I can, right? This also applies to like traffic stops. So if the cop has 100 bad reasons to pull you over, but one legal reason to pull you over, the one legal reason governs. There's case law that stands on this. We just look to a reason, any reason. And it doesn't necessarily have to be one that the officer was actually aware of. Just one a reasonable officer would have been aware of in retrospect. So we don't even have to prove that they knew about it at the time. We just have to prove that given what they knew, that they now would have a reason that is legal. So it's pretty generous. And so there's the Supreme Court case that basically says the same thing for arrests. That, that all else being equal, as long as there's probable cause for arrest, we don't get into this motives behind it. So same kind of decision. So we don't look to we only look if there's a valid reason. Presumably we need one. What would that be? We'll find out, I suppose. In addition to filing the complaint, the plaintiff also files a motion for preliminary injunction that was supported by a sworn affidavit from the plaintiff herself and her parents, the Cohoons. However, these sworn declarations are far from the final word on the events given rise to the lawsuit. Well, I mean, that is fair, right? I mean, they're just pleadings. So, I mean, they could be lying, they could be incomplete, they could be a whole lot of things, but they attach quite a bit of evidence that supports their claim, including statements from you as part of your signed police report that says, I did these things and I said these things. They seemed pretty convincing to me. The police, the he said, she said would be one thing, but we have the actual police incident report that said essentially, and I'm paraphrasing, but it said pretty much, I went to the house on the orders of the sheriff and I said if they didn't do this, there might be the threat of arrest. I'm like, I said this in the earlier stream. Thanks for telling us exactly what we have to prove. It's that's pretty clear. It's not so much he said, she said, as I say, and you also say the exact same thing. We're both saying the exact same thing. But now you're saying we're not saying the same thing. This should be entertaining. This should be very entertaining. What are they going to try to do? Are they going to try to say why the police report doesn't actually say what it says? Are they what? I don't know. I don't know what they're going to try to come up with. This is going to be very entertaining. All right, man. This is going to be good. At the time of the sergeant's visit to the Cohoon home, he had a dashboard camera and a microphone recording the events that transpired, which tell a very different story material to the case. I'm not sure how much either the camera or the dashboard camera or a microphone would necessarily record, unless he has a mic that was also being recorded on his lapel, so there might be some audio. And incidentally, I did see in the filings that they did include a USB with the audio, but the audio itself doesn't appear to be on the docket, so we can't listen to it ourselves, which is very sad. So maybe later. Importantly, what occurred at the home, based on the video, appears to contradict the sworn statements. For example, when discussing the medical records, Mr. Cohoon stated, I offered to show Sergeant Klump the documents we received from Divine Savior, but Sergeant Klump responded he was not there to gather information, just to complete the orders. The foregoing exchange simply never happened, and Sergeant Klump did in fact look at the Divine Savior records on multiple occasions. Okay. Well, if that's on video and shows that might indicate that, yeah. Okay. I mean, it's always possible that, one person is not telling the truth or not remembering things properly. And this is also a good reason why dash cam video and audio is also helpful for the police. It only does seem to be available when it helps the police. It does seem to be a situation more often than not where plenty of times we've seen where the dash cam audio or video mysteriously disappears, where it appears it would have helped the other side. But whenever it helps the police, it's available. So, yeah, okay. More significantly to the claim of the case, according to the sworn declaration, a little while later, my dad called me back outside and explained the officer was going to ask me to remove the post. My dad said I didn't have to delete it, and he wouldn't delete it if it were his post, but he would let me decide. In his sworn declarations, Mr. Cohoon swore to similar facts. However, despite being sworn declarations, the foregoing did not occur. Dun, dun, dun. Dun, dun, dun. Most significantly, according to the sworn declaration, the officer then showed me a screenshot of one of my Instagram posts and told me that if I did not remove it, he had direct orders from the sheriff to begin issuing citations for disorderly conduct and taking people to jail. I was afraid the officer would do what he said, so I agreed to delete my post. In his sworn declaration, Mr. Cohoon averred to similar facts. However, despite being included, the foregoing did not occur. Bum, bum, bum. This is good stuff, man. I like this stuff, man. We might have to actually I hope at some point we get like the audio or something so we can actually see what actually happened or some quotes or something. That would be nice. If they actually have a record of it, they could just like quote it directly. That'd be great. Instead, Mr. Cohoon tries to respond and she removed the social media post. The video establishes it was after the consent. Oh, so they're arguing consent. Well, consent under duress isn't consent at all. So there's that. She would remove the social media posts. Okay. It was after the consent and after they re-entered the home and out of the presence that the reference to disorderly conduct occurred in discussions with Mr. Cohoon. Okay, so they're saying that it was... No, that doesn't contraindicate. Because I was like, was it after delete? Okay. And just because they weren't, and simply put, the words were not entered in the presence of Mrs. Cohoon. Well, that doesn't matter. Like, if it happened to the father and the father communicated it, one way or another, that would be enough. I would, so no. I like how they say this is an issue of consent. She consented. Okay. Yeah, she consented. Sure. Let's go with that. That sounds good. In light of the undisputed evidence assembled in the case in the form of audio and video, that's not how undisputed evidence works. First of all, they haven't had an opportunity to dispute it. So the audio and video may not be complete. It might be malformed. It might not capture everything, especially if the officer at any point walked inside the house, right? It wouldn't show it, presumably, unless the door is like wide open and you can see through the door. So there's a pretty decent probability the video didn't capture everything. The audio might not have captured everything. It might not be full and correct. And even if it's full, it might not be, might not be accurate. So not quite correct to say it's undisputed. We haven't had a chance to dispute it yet. But nice try. Defendant maintains this dismissal of action as a matter of law is appropriate for the following reasons. The plaintiff was not subject to arrest, retaliation, penalty arrest, or threatened arrest. As a matter of law, the contact between Sergeant Klump and Miss Cohoon did not constitute a deprivation sufficient to deter First Amendment activity in person of ordinary firmness in a matter of law. Good. And there's probable cause for a violation of the law or county ordinance. No, there's not. Screw you. Beyond the foregoing, defendant also maintains dismissal is appropriate based on qualified immunity. Well, we all knew it was going to come up. We all knew it was going to happen. The magic words have been spoken. Qualified immunity. We all knew it was going to happen. We could see it happening a mile away. The magic words have been spoken. Qualified immunity. It is the magic words that make all the bad things go away for the police. It only took him to the bottom of page 3 to mention it. I was waiting to see how long it would take. It took him to the bottom of page 3. Okay, that's good. Beyond the foregoing, defendant also maintains dismissal is appropriate based on qualified immunity related to several elements. For reasons detailed forth below, defendant's request, the court grant motion for summary judgment and dismiss the action with prejudice. Ooh. Factual background. Tell us the facts, Sergeant Clump. Mr. Clump. Calling him Sergeant Clump is too respectful, and calling him Mr. Clump is not respectful. And, I'm a full-blown adult, and I don't give a damn about him. So I'll just call him Clump for the rest of this exercise, because I can use my freedom of speech, and screw him. Screw him. How about that? Yeah. So we'll just call him Clump, because he is a clump. The relevant factual background set forth below and the defendant's proposed findings of facts are submitted with this memorandum of court along with citations to support these declarations and evidence. In brief, Ms. Cohoon was on a band trip in Florida that was cut short as a result of COVID-19. After returning to Wisconsin, Ms. Cohoon began feeling ill, and on March 22nd, she sought treatment at the hospital in Portage, Wisconsin. She was not tested for COVID-19 and was ultimately discharged with a diagnosis of acute upper respiratory infection unspecified. Over the next few days, Mrs. Cohoon's condition apparently deteriorated and she was taken back to Divine Savior Hospital. She was tested for COVID-19 and her results came back negative. During the morning of March the 26th, the Marquette County Health Department received notification through the state's reporting session that Ms. Cohoon had been tested for COVID-19 and her test result was negative. Underline, negative. However, the health department was advised of a social media post by Ms. Cohoon after she returned home from testing negative, stating that she had beaten COVID-19. No. No. Truth is not required. They put it on her work release form, as you well know, and also the tests are not particularly accurate. So, all that. All that. The health department and school district received numerous phone calls from concerned, upset, and panicked citizens regarding Mrs. Cohoon's social media posts saying she had recovered from COVID-19. Well, just deal with it. I don't know what to tell you. Even if there's a school disciplinary action in here, which, that's a whole other set of issues to be had, right? The school disciplinary actions and stuff there. So whether or not, the school had some sort of action on falsity or whatever, that's a whole other can of worms. Right now, we're talking about the criminal law. No, none of these things are criminal. Even if there's a colorable school action to be had, which incidentally, there wouldn't ultimately be, because she'd be able to prove it. But even if the school thought it had some sort of merits at the time, there's no police action. There's no action from the cops. This is not criminal. Just because your school can do something doesn't mean the cops can. So, the administrator's concerns are super, super interesting. But what concern is it of the police? I don't know. $5 from Greg Polinsky from the chat. Thank you, Greg, for your super chat. You help make this channel possible. It is always appreciated. The department The health department, okay. The department's attempts to alleviate concerns do not appear to be able to keep pace with the growing disturbance. Again, the health department's concerns are super, super interesting, but what concern are they of the police? Ultimately, the health department contacted the Marquette County Sheriff Department, explained the situation and its concerns. Given the panic, concern, and disturbance within the community created by the social media post, I wonder how much concern the community has right now because of this social media post, the one I'm making right now, about all these people and naming them explicitly and posting it on Instagram with all the Instagram handles I can find. How much concern do you have about this Instagram? How about this social media post? How much concern do you have about this, Marquette County, you jackasses? Marquette County Sheriff Joseph Conrath forwarded an email of Ms. Cohoon's social media post to Sergeant Clump and requested that Sergeant Clump make contact with Cohoon family and inquire whether Mrs. Cohoon would voluntarily remove the social media post concerning that she had been beaten COVID-19. Voluntarily. Voluntarily. She consented. She consented, Your Honor. She was wearing that dress. It was totally okay. Sergeant Clump discussed, Sheriff Conrath discussed with Clump there would be a wide range of potential options. However, Clump would assess the situation further, and he would contact Conrath before he proceeded with any further action, particularly as it related to potentially making a referral for disorderly conduct, which it's not. It's none of these things. It's none of these things. As shown on the audiovisual recording from Sergeant Clump's squad car, Sergeant Clump began speaking with Miss Cohoon outside while Mrs. Cohoon remained inside the home. After several minutes, Sergeant Clump explained the reason he was there. Why did it take several minutes to discuss the reason you were there? What were you doing for the first couple minutes? Just out of curiosity. He was there to discuss Miss Cohoon's social media post in which she stated that she had beaten COVID-19, even though she in fact tested negative. Sergeant Clump, did he actually know that? Did he know that? The health department did, but did he know that? I don't know. Sergeant Clump, I apologize. I referred to him by title. That was my fault. Sorry. Clump relayed to Mr. and Mrs. Cohoon that the post was causing many issues with students and parents within the school district. Clump also explained to Mr. and Mrs. Cohoon that Conrath had been contacted by the Marquette County Sheriff Health Department requesting the Sheriff's Department make contact with the Cohoon family and talk to their daughter to see if they would delete her post. Mrs. Cohoon responded with okay, which presumably we mean Amyiah. Yes. Benjamin Aztec, 499. Thank you, Uncivil. You are welcome, Benjamin. You are welcome. Mrs. Cohoon, presumably Amyiah, then responded okay, at which point Clump interpreted her agreement to take the post down, though he understood that Cohoon may have not been speaking for her daughter, who appeared to have actually authored the post. Minutes later, Miss Cohoon stepped outside the residence for the first time. Sergeant Clump explained to the Cohoon family that all he was there for to figure out what the post was about, which was pretty clear on its face, but that's all right. Seeing that Miss Cohoon tested negative, see if she would take the post down. In response to the Clump statements, Miss Cohoon immediately responded by saying, "I'll do it." Well, when it's the sheriff with the badge and the gun who's making a request to a young girl in particular, the consent element is a little bit questionable. Sergeant Clump took Mrs. Cohoon's statement to be voluntarily willingness to delete the post. She seems much less willing now. After additional conversations about the Cohoon's medical course during the past week, Sergeant Clump stated, nonetheless, can we get the post taken down? In response to the question, both Miss Cohoon and Mr. Cohoon, Miss Cohoon and Mrs. Cohoon. Okay, so Mrs. Cohoon is actually Mrs. Cohoon. Miss Cohoon is Amyiah. So we're Mrs. Cohoon and Miss Cohoon. Referring to Amyiah by her last name is slightly confusing. Okay, so it's the mother and her. All right, because the father was also involved. It was getting a little confusing. All right, so in response to this question, both her and the mother agreed to take down the post by stating yes. After agreeing to take down the post, Amyiah walked inside and closed the door behind her. While Amyiah was outside of Clump's presence, and after she already said twice she had removed the post, Sergeant Clump did state to Mr. Cohoon, Richard, I don't want it to go this far. It was simple as me coming out here and just letting the post being taken down and walking away. While he made these statements and mentioned disorderly conduct and arrest, Miss Amyiah was not present, but rather was inside the home with the door closed. I don't mean any disrespect to Amyiah by referring to her by first name. That is not my intention. And if it were just her, I'd be happy to call her Miss. That'd be fine. Because it shows her the respect I think she's due. The only reason I'm calling her Amyiah is because also her mother's involved. And so it got a little confusing as I was looking at pronouns, trying to figure out who we're referring to. So please don't take this as a sign of disrespect, Amyiah. You have my utmost respect. So I would refer to you by last name, but it's a little confusing. So just trying to keep the who's talking to who straight. Unlike Mr. Clump, who doesn't even get to be called Mr. because he's just a clump. He doesn't get respect. Several minutes later, Amyiah reemerged from the house with her hand and confirmed the social media posts had been taken down. Sergeant Clump told Amyiah that he appreciated her taking down the post, and she responded, "Of course." This seems like a very charitable telling of this tale. It seems like a very charitable telling of the tale. Yeah, this seems like a very charitable telling of the tale. I went to the house. And I just knocked on the door, and they came rushing outside and say yes. And I said, I don't want to impose on you in any way or anything. We're just a little concerned about, some sort of issue with this post. Oh, post, I'll be happy to take it down right away. Take it down, no problem. Oh, okay. It's a little charitable telling of the tale. Don't quite buy it. Don't think it quite happened that way. A little skeptical. That's the way it went down. Importantly, the proceeding, and again, if we ever actually get the audio, maybe we'll be able to say, oh, wait, the sheriff was actually right all along. In which case, we'll apologize. But based on, the police officer's own written report of what they said and did, there was that. The actual written report, the actual incident report that was filed. Seemed a little damning. So, there's that. The preceding factual description of what occurred at the home, based on the video, is it though? Appears to contradict the sworn declarations filed by both the plaintiff and the father. As discussed above, Amyiah's sworn statement that Clump told her he had direct orders to issue the citation for disorderly conduct or take people to jail did not occur. From the video's evidence, there was never any threat made to Amyiah, and the reference to disorderly conduct occurred outside her presence. I don't know again that I buy that. If you're a young girl and a police officer comes to your door, and they make what seems to be a request. Are you supposed to know it's a request? Right? So her capacity to consent is a little questionable at best. And I was just requesting. Yeah, you were doing so in full uniform with a badge and a gun and a police car outside, possibly with lights on. Who knows? But I'd guess, if I had to guess, the lights were on or something. So, there's a little bit of intimidation there, perhaps, just maybe a little bit. Okay. Also, Clump, you're a jackass. You want to come to my home? I'll give you my address. It'll be a bit of a drive, but what do I care? All right, so let's talk about summary judgment. What is the standard for summary judgment? Summary judgment is required if the pleadings, depositions, answers, and admissions, together with affidavits, if any, show there's no genuine issue. That is true, right? If there's no genuine issue, if you look at all the evidence, and there's no issue for a jury to resolve, then you do summary judgment, right? So they're saying they're there. It may be a little premature. It may not be premature. Depends on what Amyiah's attorney wants to do. And we haven't gotten that far in trying to analyze what we think is in our best interest. So I don't know what's in our best interest yet. Maybe as we get further, I'll be able to try to make an opinion as to which way I think is the way to go. But I don't know yet. I mean, all things being equal, I'd probably want to do a deposition of at least the sheriff on top of it. But I don't know yet. It also depends what's on the tape that I'd want to know. That would be pretty interesting information. So it's a little premature for me to say what I'd want to do. The court should not weigh the evidence to determine the truth of the matter, but determine whether there's a genuine issue for trial. Yeah, it's not a weighing of the evidence, because you just determine whether there's an actual issue. Does the record conflict in a material way? Is there a material issue to be resolved? Right. So the evidence can conflict, obviously, but as to a material issue, as to one of the elements of the crime, for example, or elements of the tort. The mere existence of some alleged factual dispute between the parties will not defeat an otherwise properly supported motion for dismiss. Yeah, just because there's a fact in dispute is not enough. It has to be a material element. If we disagree on if the issue is the cop came by at 7 and the everybody says they came by at 9, does it matter whether the cop came by at 7 or 9? It really doesn't matter. Either way. Either way would have been fine. So if you say 7 and I say 9, as to this particular issue, it doesn't matter. So, like, if that was the factual dispute, who cares? It's not an element that matters. 7 or 9 will work perfectly fine either way. We don't care about that particular fact. So that's the kind of thing we're talking about. They must view the facts in the light of the favor to the non-moving party and draw all reasonable inferences in that party's favor, but need not ignore facts unfavorable to the party because it only receives the benefit of doubt of the record if it presents evidence of both sides of a question. Right. So you look to the evidence in the light most favorable to the other side and you try to figure out if there's enough to go forward. Right. So like it basically like, you pretend like in your head that you're at trial and you look to like the evidence in that light most favorable, and if they put all the light, did they make enough to make their case? Right? Did they put forward enough evidence to make their case in the light most favorable to them? And if not, there's nothing for a jury to do. So that's what you do in summary judgment. When the record taken as a whole could not lead a rational trier of fact to find for the non-moving party, there's no genuine issues of trial. Yeah, so like you look to the evidence and you try to say, like, could, in the light most favorable to the one side, to the other side, right? Because you have to look into the light of the, so in this perspective, we're looking to Amyiah's side, because this is a motion of summary judgment from the sheriff. So we're looking at this from Amyiah's perspective. So if Amyiah presents all the evidence from her point of view that she has and all the evidence that's of record, is there either A, a genuine issue of material fact for a jury to resolve, or B, if there's not, could a jury rule in her favor? Right? If there's no issues of fact, there's nothing for a jury to do. If a jury couldn't rule in her favor, there's nothing for a jury to do. So that's the right standard. Notably, the rule mandates this entry against a party who fails to make summary judgment. Yeah, it says that, but, how mandatory that is depends on your judge of choice. There's these things are interpreted by judges. So some judges look at that a little bit more skeptically, although there are quite a lot of judges who will happily spring in an excuse to dispose of something on their docket. So it depends a little bit on the temperament of your judge, as you might expect. This is a bit of a human endeavor. So like the person looking at this thing does actually matter, which is one of the reasons you want to have good judges, because, if they don't have good judges, they will do the wrong thing sometimes. So the judgment should be granted. This part isn't under oath. No, this part isn't under oath. This is the motion. But there is affidavit from the cop. We haven't gone that far. I'm saving that for later. But we do have an affidavit. This part isn't under oath, but we do have an affidavit. And this is putting this is as of always putting everything in the best possible light for the sheriff. But we will actually get to the sworn statements from the sheriff. We haven't gone that far yet. We'll get there later. Hang on. Maybe we won't get there if you're not good. Maybe we won't get there if you're not a good chat. In order to succeed on the First Amendment retaliation claim, Ms. Cohoon, Amyiah, and I'm not doing that out of disrespect, but just to try to keep the party straight, because your mother also got involved. It got a little confusing there for a second. Amyiah must show that she engaged in protected First Amendment activity. She did. We're going to kind of try to do that, deny that. That'll be good. She suffered a deprivation that likely deter First Amendment activity in the future, and the First Amendment was at least a motivating factor. As the second factor, retaliatory speech is generally actionable only if the situation of threat, coercion, or intimidation that punishment, sanction, or adverse action will immediately follow. Yeah, that's fair. That's a fair characterization of the law. Could I do a FOIA? Maybe. But it would take longer than it would pop up in the docket. But yeah, I suppose I could. Maybe I should file a FOIA. That'd be hilarious. And maybe I should file a FOIA for the video and audio records. That's not a bad idea. Maybe I'll do that and see what happens. Yeah, that could be fun. Ms. Cohoon alleges after she showed a screen, but it depends how eager they are to let that get out. So, like, they're making representations to the court, but how eager they are to, like, let that come to me, who knows? But yeah, maybe I'll file a FOIA just to see what the hell happens. Maybe they'll take, forever and a day to get to it, or maybe they'll just give it to me right away. That'd be hilarious. I'll send them a fax on Monday. I'll send them a fax. I'll do it a little informally. So I won't do it through the formal channels. I'll just send a fax straight to the sheriff's office and be like, hi, I'd like a copy of this. Please, would you just give it to me? That'll be great. Thanks. Let's see if I can get a response. You can send it to me at this email address, or you can put it on this link for Google Drive or something. Yeah, I'll figure out a way to get to it. That'd be good. Upload it to my YouTube channel. Yeah. Amyiah alleges that after she showed a screenshot of the Instagram post, Klump told her that if she did not remove it, he had orders from the sheriff to begin issuing citations for disorderly conduct and taking people to jail. Amyiah and her father both submit sworn declarations echoing this allegation that Klump told Amyiah that she did not remove the post. He had orders to begin doing the arrests. For the purposes of the second element of the retaliation claim, an adverse act or deprivation, Amyiah characterizes the alleged statements Klump made to her as a threat of arrest. However, as established by the recording, Klump never spoke to Amyiah about citations for disorderly conduct, taking people to jail, or even the notion of arrest before or after Amyiah voluntarily deleted the post. Rather, the record shows a brief, straightforward exchange between Klump and Amyiah, where Klump asked Amyiah to remove the Instagram post, and both Amyiah and her mother agreed to do so. Amyiah is becoming a girl of legend in this community. She is just this is becoming great. This is just great, man. It's like, and I applaud her for it too. She should stand up for her rights. I really do applaud her. I think she's wonderful. She's showing strength. Kick ass, Amyiah. Kick the police's ass. Fight the law and you win. How about that? That'll be good. In short, the allegations are sworn statements that Klump threatened Cohoon with emergency with citation, arrest, or jail if she failed to remove the Instagram post are at best misstatements. I think even referring to him as Klump is too nice. So maybe I should just refer to him by something else. Maybe I'll just call him Jackass Liar. That'd be good. I'll just call him Jackass Liar for the rest of these proceedings. Because I can. He's now Jackass Liar. In light of the recording showing the conversation, the court is under no obligation to accept Amyiah and her father's versions of the facts. When two opposing parties tell two different stories, one of which is blatantly contradicted, so no reasonable jury could believe it, a court should not adopt the version of the facts for the purposes of ruling on the motion for summary judgment. Moreover, given the blatant contradiction in the sworn statements submitted by Amyiah and her father, the cases in which Amyiah relies in her brief are inapplicable here. Even notwithstanding the fact that Jackass Liar did not threaten Amyiah with arrest, Amyiah's reliance on these cases is misguided because they're factually distinguishable from the circumstances of this case. At this point, I'm just guessing that this stream will be demonetized. So if you just want to contribute that way, be nice. The Seventh Circuit's decision in Farley did not involve alleged retaliatory threats of arrest of a citizen, but instead focused on retaliatory death threats guard jails made against former co-workers who attempted to file internal complaints and planned to testify about witnessing the mistreatments of inmates. Thus, this case provides no support for the plaintiff's position, particularly in light of the inaccurate statements of Amyiah and her father's declarations that Jackass Liar directly threatened her with arrest. So yeah, the case in Farley is a more extreme fact pattern because the threat is more extreme, but the logic of it seems to apply. So to me it seems applicable on it, that's fine. Stifel and Hotchkiss are even further from the market. Neither of these cases involved First Amendment retaliation claims. Who cares? As long as the retaliation claims, it doesn't matter, In Stifel, the Supreme Court held that a plaintiff could challenge the constitutionality of a state criminal statute under the Federal Declaratory Judgment Act, even in the absence of state prosecution, because a genuine threat of enforcement of a disputed state criminal statute constitutes an active controversy. Thus, the Stifel court was not asked to determine whether the threat of arrest, the existence and probability of which was not in dispute, was sufficient to constitute deprivation. It was only asked whether a realistic threat of enforcing an allegedly unconstitutional statute was sufficient to create an actual controversy. At least to my lawyer mind, there's not quite a lot of daylight between those two things. Let's read that again and try to figure out where the daylight between those two things are, because I didn't get it the first time. Maybe if I read it a second time, I'll see more daylight than I did the first time. Let's give it another go. Thus, the stifle court was not asked to determine whether the threat of arrest, the existence and probability of which was not disputed in that case, was sufficient to constitute a deprivation for the purposes of the First Amendment retaliation claim. Okay. It was only asked where the realistic threat of enforcing an allegedly unconstitutional statute was sufficient to create an actual controversy, such that the plaintiff could seek declaratory relief. Therefore, it's inapplicable. I read it twice. And other than the fact that in that particular case, it was talking about declaratory relief, which incidentally is what they're seeking here. One of the causes of action is declaratory relief. So there's not even that in common. Because I was about to say, well, there's that element that's different, but there's not even that element that's different. Because one of the elements that Amyiah is asking for is declaratory relief. I remember it in the complaint. So having read the sentence twice, I don't understand what they think the difference is between the two things. Maybe if I read it a third time. What are the difference between these two things? The stifle court was not asked to determine whether the threat of arrest, the existence and probability of which was not disputed in that case, was sufficient to constitute deprivation in a First Amendment claim. It was asked only whether the realistic threat of enforcing an allegedly unconstitutional statute was sufficient to create an actual controversy such that the plaintiff could seek declaratory relief. How are those not the same thing? How are those two different things? How are those two different things? It sounds like the same thing. I mean, they're slightly different words, but you said the same thing twice. Those are the same thing. I'm confused. Okay, it's inapplicable for some reason. I don't understand why, because it sounds suspiciously like you said the same thing, but okay. I'll take your word for it, counselor. Maybe I'm just missing it, I guess. All right. I skipped over the word retaliation. It's deprivation for the purposes of First Amendment retaliation claim. Okay. It asks only where the realistic threat of enforcing an allegedly unconstitutional statute was sufficient to create an actual controversy, such the plaintiff could seek declaratory relief relating to the constitutionality of a statute. I'm still no wiser. Than I was before. I haven't read it a fourth time. Still in Hotchkiss, the Seventh Circuit upheld a class action facial constitutional challenge to an Indiana curfew law, $5 from Spartan Chuckles, or $5 Canadian, thank you. Because they're trying to protect jackass. That's right. Yeah, pretty much. Yeah, yeah. It's like I don't see it, ma'am. I don't see the difference. Not a lot of daylight in that between those two to me. I'm not seeing the daylight, but okay. Similarly, in Hotchkiss, the Seventh Circuit upheld a class action facial constitutional challenge to an Indiana curfew law because the law was not narrowly tailored to serve a significant governmental interest and restricted the minor's access to any public forum during curfew hours, with no significant reduction in the chance that a minor could be arrested for exercising his or her First Amendment rights. One of the minor plaintiffs, in fact, had been arrested on a previous version of the curfew law the district court had found unconstitutional. Although an amended version of the law was before the Seventh Circuit, the court reasoned that the concrete possibility of arrest for violating the law that made the amended version no better than the prior version, which contained no provision at all for the exercise of First Amendment rights. Thus, the threat of arrest referenced in Hotchkiss did not refer to a law enforcement officer's alleged threat of an arrest made to a citizen in order to chill speech, but instead referred to the reasoning in Stifle that a facial challenge to an alleged unconstitutional criminal statute could be maintained absent prior or ongoing prosecution of a plaintiff pursuant to that criminal statute. Which, if anything, sounds helpful for Amyiah. Right? So, okay, so this attorney says that Hotchkiss referred to the reasoning in Stifle, That said, a facial challenge to an allegedly unconstitutional statute could be maintained absent prosecution, which is kind of what we're doing right now. I mean, this is even more the other way. Like this case is more favorable to Amyiah than not, because this case didn't even involve a threat of arrest. That case didn't even involve that threat of arrest. So it didn't even have that element of it, which was here, right? It didn't even have that element. So that case actually goes further the other way in saying, you don't need actual arrest. You don't need threat of arrest. You just need a statute and some reason to believe there might be an arrest, and you can believe that based on prior arrests. So that case that case is the wrong way, but in Amyiah's direction. It sets the boundaries more favorably to Amyiah, not less favorably. So, it's better for her that it's in that direction. Because it's like, you don't need the line to be here. It's over here, and I'm here. So, okay. $2 from Tate and Raider. Spartan Chuckle's not who you know. A little bit, yes. 10 whatever dollars. I forget. Polish dollars from Jan. Just remember my pro se case. Will you be in voice chat? I don't know. Depends what my energy level is later. £2 from Dave Youngson. You think their lawyer is trying to screw them? Whose lawyer? Amyiah's lawyer? No. I think this lawyer. No, I'm saying that the case. I'm saying that or you mean, do I think that do I think the sheriff's lawyer is trying to screw them? No. I don't think he's trying to screw them. I think he's trying to get one past the court. Is what I think he's trying to do. Because I think these are weak arguments. They're weak arguments, which we kind of expected at the start. We expected weak arguments because the case seems so clear on first impression. Because once again, we had the actual police report. That was kind of what did it for us, right? That's where we got on the choo-choo all on board for Amyiah train, because we had the actual police report that actually said, I went to the house. I wanted to take it down. I did so on the orders, and there was a possibility of arrest. That's where we got on the Amyiah train. Where we had the actual police report that said, oh, this is exactly what we're trying to prove, right? So, we weren't, expecting really great things. And their attorney is doing what I would want. In a lot of ways, their attorney is better than me. Because I don't know that I could be this creative. Now, to be fair to myself, in that respect, I haven't spent whatever number of years that this attorney has spent as the city's lawyer, or he's either the city's lawyer or he's worked in these kind of contexts before, right? So he's used to these kinds of things. So he's used to being creative in these kinds of directions, right? So I don't focus in this area of practice. So if you asked me to defend the sheriff, I could not do this well, right? I can still spot the flaws after the fact, because I know enough to be able to spot the flaws, but I wouldn't be able to make these arguments. They're just tenuous enough to be plausible, or not plausible is not the right word. They're just tenuous enough to not be laughable. So I don't think he's trying to screw them. I think he's just trying to do the best job he is. And I think he's doing a reasonably good job, actually. I think he's doing a pretty good job. Unfortunately for him, his client sucks. And you can only do so much for your client when your client sucks garbage. And we've seen this before when we've had oral react cases, right? We've seen this before where we've seen someone get up and do a really good job defending someone. We saw it in the Benson versus Blue case, where it wasn't the cop's lawyer who completely sucked it, but the city's lawyer. City lawyer did actually a pretty good job. She did a really good job. She was really solid, made really good arguments. Unfortunately for her client sucked, and they wound up settling, but she did a really good job. So I don't think this attorney's trying to screw them. I think he's doing a very good job. I just don't think it's going to win, because his client sucks. There's only so much you can do. There's only so many rabbits you can pull out of so many hats. Yeah. You know, there's only so many rabbits you can pull out so many hats. £2 or $2 from Robert Zaz, so not trying but probably succeeding. I don't know. Some of these arguments seem a little weak to me. I know we've got our first members. Yay! Thank you for joining as members. Yay! I'm glad to know it works. Yay! Thank you for your support. I made it 99 cents so that everyone could join. I want it to be relatively inexpensive. And right now, as a member benefit, you get access to like the live streams I do when I do weekly batch recordings. Ooh. And like I did one earlier today where I did a 4-hour watch me game and ask me question streams. And that has been archived, but it's available to members. So you, my friends, get to watch that 4-hour stream if you want to watch me play Prison Architect and answer legal questions. It's pretty good. Thank you, Jan, for your contribution, for joining. I appreciate it. The facts and reasoning of Hotchkiss are uninstructive to this case, where Miss Cohoon, Amyiah, alleges the First Amendment deprivation resulted in a threat of arrest by a specific law enforcement, non-officially unconstitutional criminal statute. Yeah, but that's more in the right direction. Thank you. Thank you, Dennis. Thank you, Abrahoff. Thank you, Dogbert, and thank you, Jim Keel. Yes, it's a dollar. It's a dollar to holla. It's a dollar to holla at the Uncivil Law House. Thank you, Robert, for your $1. Very good. And you get to use your Google rewards. Very good. Thank you so much. It's a dollar to holla at the Uncivil Law House. Yeah. In light of the clear audiovisual evidence of the cause identified, these cases are all inconsequential here. At least 2 of the 3 are definitely not. Thank you, Ryan. By contrast, Amyiah's sole theory of First Amendment retaliation is premised on her unsupported allegations that jackass liar threatened her with arrest. Yeah. Based on the claims alleged in video evidence, this court's decision in Black is far more instructive. In Black, this court held as a matter of law that Milwaukee County former Sheriff Clark did not deprive the plaintiff, Black, of his First Amendment rights to free speech by directing deputies to stop and interview him at an airport in response to Black having stared and shaken his head in displeasure at Clark on the plane. Why would you do that? Putting aside the legality of it for a second, let's just take a note of what just happened. So this guy, Clark, is the sheriff at the time. And he's sitting on a plane with some other guy. And this other guy apparently stared at him for a while on the plane and shook his head at him. And this sheriff asked his deputies to interview him. Putting aside the legal questions, why? That's good. Thank you, Ryan. Thank you, Quid Pro Bro. And thank you, El Rio Grande. Thank you so much. It is appreciated. Yeah, so putting aside the legal questions, why? Okay. I guess some police are really soft-skinned is all I can think, including Mr. Clark. Turning to whether the act of directing deputies to interview Black constituted an adverse action, the court considered whether the action would deter a person of ordinary firmness from exercising First Amendment rights. Importantly, the court noted that Black voluntarily submitted to the interview with deputies at the airport. Voluntarily. Just don't talk to the police is a pretty good tip, all things being considered. If the police come to you and say, "Can I talk to you?" just be like, "No." That'd be good. Interviews can be friendly new ways to meet new people. I guess, man. Jeez. And the court found that Black was not deprived of anything or made to do something he did not agree to. The court noted, for instance, that Black had been issued a citation. Had he been issued a citation, fined or arrested, then perhaps retaliation would have been different. However, concluding summary judgment was appropriate, the court found that Black had not shown that, but simply being stopped for 15 minutes in order to voluntarily respond to questions would likely deter First Amendment activity in the future. Thank you, collector, to the supporters. Yes, thank you for that. It is very appreciated. Thank you, Ricardo Ospinilla, for your membership. It is appreciated. Thank you. You get a fancy little colored thing next to your name to say you're a dollar supporter. Until I come up with more interesting donation levels, which I have no idea what that will be. But yeah, I don't know. Beyond the audiovisual evidence clearly shows no such threat of arrest was made, her interaction with Jackass Liar while in the presence of both of her parents looks much more like the brief voluntary interview Black experienced at the airport. No threats were made. No citations were issued and no results arrested. Just like in Black, Amyiah had not cited any authority for the proposition being asked to submit to voluntary questioning by police in response to Speech Act would deter a person from exercising. Well, there's a pretty big factual difference between the two. Voluntary questioning is one thing. First of all, there's a couple big differences. First of all, it's an adult. And second of all, it's questions as opposed to statements or orders, even in the guise of a question, right? Because, like, maybe it was, would you mind taking down the post? Now, if that's an order in the guise of a question, that's material. Like, would you mind answering the questions like, why are you shaking your head at the officer? I don't know, because I thought he was a jackass. Do you not like peace officers? Not really, particularly, no. I think they're all scum. I don't know what kind of questions you're asking, but, if that's, you can talk to the police or say, I think police officers are great. I was shaking my head because, I don't know. It's, whatever. Thus, Amyiah cannot show that Jackass Liar engaged in the adverse act, specifically the adverse act of threatening arrest, such that the act could constitute First Amendment deprivation. Accordingly, summary judgment is appropriate. The audiovisual evidence not only shows the lack of accuracy with the sworn statements, it also shows the falsity of the alleged circumstances surrounding the actual removal of the post. Amyiah's sworn declaration states the officer showed me a screenshot and told me if I didn't remove it, he had direct orders from the sheriff to begin and taking people to jail. I was afraid the officer would do what he said, so I agreed to delete it. Amyiah's sworn declaration is in lockstep with her father's sworn declaration is in lockstep with Amyiah's declaration. Too many pronouns. However, the recording shows no other such exchange occurred. Rather, at 1907 of the video, Amyiah states, I'll do it in response to the request. We definitely have to get a copy of this thing. Maybe there's a copy on the record somewhere. If there's a copy on the record somewhere, I'm going to go dig around for it. If there's actually a copy, because they keep doing citations, and maybe there's a copy, an attachment somewhere. If there is, we're reading it, because that'll be good. Hold on, let me double check and see if I missed an attachment or something, because I definitely want to see if there is like a hold on, bear with me, please talk amongst yourselves while I briefly look to see if there is like an actual copy of this thing. Talk amongst yourselves while I look at the docket. It's her brief proposed finding of facts declaration. No. We have a statement from the sheriff. We could do the sheriff's statements. Well, we're not going to do that tonight. We might do that on Monday or something. Warren, Jamie, Candace, Jamie Pop, Christine, declaration, emergency stay-at-home poster. It doesn't look like this thing that they're referring to is here. Unless it's like somewhere. How long is this document? 31 pages? Unless it's at the bottom of this thing, which would be really weird because it doesn't seem long enough. But they keep doing these citations to things that are not on the record, which is really, really weird. Unless I'm missing it, which is quite possible. Answer, motion, brief, proposed findings of fact, declarations. I don't see it. Okay, back to the thing. Thank you, Kate, for the membership. I appreciate it. Yeah, they might be at the end of the document. We'll see. We'll see. Yeah. Okay. Right at 1907, she says, I'll do it. In addition, in 1910 of the video, Amyiah and her mother both respond yes to when Sergeant asks, can we get the post taken down? Moments after the exchange, her mother instructs Amyiah to go inside. At no time during the period that Amyiah was in the presence did Sergeant Clump threaten, coerce, or otherwise force Amyiah to remove the post. Rather, her mother and Amyiah immediately and voluntarily agreed to Jackass Liar's request. While Amyiah was inside the house and Jackass Liar continued conversing with the mother and father, the mother stepped inside the house for a moment, stepped back outside to inform Jackass Liar that she's taking it down now. Constitutional law has recognized that citizens' ability to consent to specific acts and ability to consent to proceed under specific circumstances that might otherwise be interpreted as encroachment. For example, although the Fourth Amendment prohibits unreasonable searches, it can also permit the police to conduct warrantless searches without probable cause if an authorized individual consents to the search. This is true even when law enforcement fails to advise the person asked to give consent of the right to refuse. Yeah, that's very fair. That's true. Yeah. Here is shown by the clear audiovisual evidence, Amyiah and her mother, while in the presence of her father, voluntarily consented to Jackass Liar's request to remove the subject Instagram post. Just as the plaintiff in black, who voluntarily responded to the deputy's question, was not made to do something he did not agree to do, Amyiah cannot produce any admissible evidence to contradict the audiovisual evidence showing her voluntarily consenting to Jackass Liar's request. The unequivocal voluntary consent of both Amyiah and her mother dismantles Amyiah's present characterization of the removal post as a choice she made under threat. Thus, because Amyiah gave informed voluntary consent to Jackass Liar's request, sure she did, she cannot establish she suffered a constitutional injury. Accordingly, summary judgment is appropriate. Plaintiff cannot succeed on her First Amendment retaliation claim because she cannot establish defendant's conduct caused her to suffer an injury that would chill a person of ordinary firmness from engaging in First Amendment activity. Okay. According to plaintiff, defendant allegedly threatened to cite, arrest, and jail her, and her parents if she did not remove them, has had an ongoing chilling effect. Specifically, Amyiah alleges that Jackass Liar showed Amyiah the screenshot of the post and told her if she did not remove it, he had orders from the sheriff to begin taking citations down, which is in keeping with your written record of what he says. Out of fear that Jackass Liar would follow through with the threat to arrest and jail her, Amyiah agreed to delete the post. She showed the Jackass Liar her Instagram post on her phone as proof she had removed it. In support of her claims, Amyiah cites to Hodgkins for the proposition realistic threat of arrest is enough to chill First Amendment rights. As established in the preceding section, Jackass Liar never threatened Amyiah with arrest or any adverse law enforcement action if she did not remove her Instagram post. In other words, as was the case in Black, there are no actions or statements made by the sheriff or Jackass Liar that would likely chill a person of ordinary firmness from continuing to engage in the activity. Thank you, Q Squared, for your membership. It is greatly appreciated. Thank you. The interaction between Jackass Liar and Mrs. Cohoon was cordial and far from even approaching the level of threat sufficient to chill speech of a person of ordinary firmness. Throughout the entirety of the contact, Jackass Liar's interactions with the families were professional. I guess it depends on what we mean by professional. And straightforward in that he listened to the Coons. Reviewed documents provide him explain the family more than once. He was only there to see if Amyiah would take down the social media post. Given the panic, it was concerning. Yeah. He was only there to see if she would. But what is the threat, real or implied, or perceived by the cop car, with the guy and all the rest of it? The undisputed record shows Amyiah agreed on 2 separate occasions to take the post down prior to there being any suggestion, insinuation, or alleged threat that anyone could face arrest or adverse law enforcement action. Sure. The record of the incident dispels any allegation that Amyiah only removed the Instagram post because of Jackass Liar's threats of jail and arrest. What court is this in? This is in the Federal District of the Eastern District of Wisconsin, I believe. I think it's Eastern. One of the district courts of Wisconsin. It's in Federal District Court of Wisconsin, one of them. I think Eastern. Yeah. Let's see, where was I? The record of the incident dispels any allegation that Amyiah only removed the Instagram post because of the Jackass Liar's threat of arrest. While Jackass Liar later had a short discussion with the parents about potential for disorderly conduct due to the fact it was causing a disturbance, this was outside the presence of Amyiah and took place only after she agreed to twice remove the post. It's in the Western District. Well, I had a 50-50 chance. I guessed wrong. Oh well. Western District of Wisconsin. Yeah. Perhaps even more tellingly is the fact that on this date, the sergeant with the Jackass Liar did not chill or otherwise impact the father from engaging in or continuing to exercise his rights. Unlike plaintiff, father was present for Jackass Liar's reference to disorderly conduct. However, the father has continued to publicly voice his opinions and thoughts about the diagnosis and encounter with the Marquette County Sheriff's Department, as have I. My thoughts are plentiful. Yes. Yeah. Is it ED? If it's ED, it's Eastern District. Yeah, if it's ED, it's Eastern District. Well, yeah, I don't know. It's one of them. Okay, it's Eastern District. Okay, so I was right the first time. It was one of them. Whatever. Perhaps even more tellingly is the fact that okay, let's scroll on. In a lengthy post, the father relayed his versions of what took place and encouraged all to share his post by sharing the hell out of it. Yeah. Okay. Well, I'm going to find the father's post and I'm going to Instagram tag him too. This is going to be great. Yeah. The father continued to post about the incident reference in the hospital and asserting the sheriff and school administrator forced Amyiah to remove by threats of arrest and disorderly conduct. The father continues to post numerous times about the interaction, and his actions belie any argument the defendant's actions would deter a person of ordinary forgiveness. Well, there's a difference between the father and Amyiah. Jackasses. So, yeah, it hasn't deterred the father because he's an adult and knows better. We're talking about Amyiah, you jackasses. There was probable cause. Oh, please tell me tell me why there's probable cause. Okay, there's absolutely no way on God's earth I'm going to get this name right. I'm still going to give it my best. Amyiah Cohoon gives me $8.99 in Polish dollars and saying you're surprisingly popular in Poland. How did I do? Did I get close? Lord. Probable cause is a fluid concept that relies on common sense judgment of the officers based on totality. It is only a probability or substantial chance of criminal activity, not a certainty that crime was committed. Chai Chai Oni. Chai. Okay. Yeah, we're doing what we can over here. It is only a probability or substantial chance, not a certainty the crime was committed. And the harder probable cause is what the police know, not whether they know the truth. That's making the determination of the test is objective, whether a reasonable officer would believe a person had committed. If so, the arrest is lawful, even if belief would have been mistaken. Importantly, eyewitness complaint or information is sufficient in and of itself to form probable cause. Who cares? Probable cause to justify arrest means facts and circumstances within the knowledge are sufficient to warrant a prudent person or one of reasonable caution in believing under circumstances a suspect is committing or about to commit the offense. Please tell me why there's probable cause under any of those definitions. Yeah. So if anyone, since Robert pointed to the link, if you guys happen to find what this thing is pointing to, this citation, or you happen to find the transcript of the thing somewhere in there, let me know, because I'd like to just tell me what docket entry it is so I can pull it if you find the whatever they're referring to. Q squared for $1.49, it's appreciated. So yeah, I did see the thumb drive was deposited, so I would love to get a copy of that. That'd be great. Wisconsin's disorderly statute states whoever in a public or private place engages in violent, abusive, indecent, profane, boisterous, unreasonably loud, or otherwise disorderly conduct under circumstances which the conduct tends to cause or provoke a disturbance, which, how does that apply online, is guilty of disorderly conduct. The county ordinance is identical to state statute. The phrase otherwise disorderly conduct, as used, means a type of conduct not previously enumerated, but similar thereto, and having a tendency. Yeah, well, that's how you normally read like catch-all phrases. You normally read catch-all phrases as being in the same light as the things that came before it. So you read it in the same context. So when you're looking for like these catch-alls, it's in the same genre as that other stuff. Okay, the disorderly conduct statute does not require showing there was in fact a public disturbance. Disorderly conduct includes behavior that may have or tended to provoke or aided in breaching a peace. Yes, that is correct, but you're using it for the wrong proposition, because that is essentially disorderly conduct. That is essentially disorderly conduct, is breaching the peace, right? Because again, like, we think about what this is in the real world, and this is a person who is disrupting the peace, right? So I use the Starbucks coffee shop just because why not? It's an illustration that makes sense. Lots of people know what coffee shops are like. So it's like, a person using vociferous profanities, a person who's egging people on, a person who's throwing punches, a person who strips naked, a person who is disrupting the peace of the environment. Everyone else is there engaging in peaceful conduct. They're all there for a common collective purpose. And then this jackass comes off the street and starts behaving in a way that's completely antagonistic to everyone else. So it's disrupting the physical environment. That's like breach of the peace, right? Makes sense. Like the analogy we're talking about makes sense. So how does it apply online? I don't know, but I'm sure they'll be informed. $5 from Ricardo Ospania. Thank you for the super chat. It is super appreciated. How is the police coming to your house demanding that you take down a post not a threat when they come to your house where else is implied? I'm kind of with you, Ricardo. I'm kind of with you, Ricardo. There's a bit of a threat implied, and because let's take for granted like what the police are saying, right? So if the dash camera can show anything, right? If the dash camera can show anything, how is that possible? How is it possible the dash camera shows anything? Okay, let's think about this for a second. How is it possible the dash camera, if it shows something? Now, the audio we can get behind because the mic, radio transmitter, right? But we're talking visual. How does the camera see anything? Well, the camera points out of the dashboard. Points front, right? It sees everything you would see if you were the driver, which means that for the dash camera to see what's happening at the front door means what? The car is pointed to the front door, which means that this car is not on the sidewalk, parallel to the, push point up the sidewalk where he got out of it, right? Because that would be parallel. It's pointing the wrong direction. That means this cop car came up the driveway and is like sitting on the driveway, right facing it, in order for this camera to see anything. So that's a little intimidating, right? That's what I think. Q squared, $10. Thank you so much for $10, Q squared. You are awesome. Will be hard to chill the speech of a minor. Actually, super easy. Barely an inconvenience, man. Yeah, that's what I'm thinking. Super easy. Barely an inconvenience. Yeah, exactly. So it's like, yeah, I'm on board with you. El Rio Grande, $5. Yeah, jackass liar. Very cute. Very nice. Yes, very good. Oh, that's a good one, man. Very fun. Yes, thank you. And for what it's worth, I thought I disabled Nightbot. I thought I deleted Nightbot's permissions because it was being interfering. But I saw it was silencing someone earlier. So apparently I failed in my efforts to silence Nightbot, which is annoying. Hold on. I refuse to be beaten by a bot. I'm going back into my settings and I deleted you. Where are you? Nightbot doesn't have permissions on my channel. Nightbot doesn't even have permissions on my channel. It's not a listed moderator. What is this crap? How is Nightbot doing anything? It doesn't have permissions. It doesn't have permissions. Nightbot has gone rogue. Nightbot's gone rogue. Nightbot doesn't have permissions. Yikes. We got hacked by a bot. That's good news. I'm going to have to look into that later or something, man. Jeez. Wow. Disorderly conduct does not require there to be a showing. Okay. Wisconsin's disorderly conduct does not prescribe all conduct that tends to annoy other persons. That's true, it doesn't. But rather only that which reasonably offends the sense of decency or propriety in the community. Right. Both probable cause and disorderly conduct are flexible concepts without a fixed definition. Well, that's true for half of it, but not the other half. I mean, disorderly conduct is not that flexible. A police officer's probable cause determination depends on elements of the applicable statute. To determine whether there's probable cause to believe that Amyiah social media post met the definition. Yeah, Big Bot is watching you. Yeah, I guess I could ban Nightbot. That's actually a good point. Well, someone who's not a mod, type in all caps and see if it like hides them so that I can ban Nightbot, because I refuse to be beaten by a bot. So take one for the team and like type in all caps and let me know if it silences you, because I want to ban Nightbot. That's the only way I know to do it. There it is. Hold on. Stop typing. Okay, wait. Stop. Okay, let's see. Hide user. It's not even listed as a moderator. How are you doing anything on my channel? Hide user? Will that work if I hide user? Because you can click on the 3 little dots to add as moderator. And it's not listed as a moderator, because like anyone who owns a YouTube channel will know this, right? When you like, you can like click on any user, you have the 3 little dots over to the person's name, and you can add anyone as a moderator using those 3 little dots. So when I clicked on Nightbot's 3 little dots, it says add as moderator. It isn't even listed as a moderator. How does it have authority to do this? Okay. Yeah. Anyways, I didn't realize when I signed up for Nightbot that I was signing up for like a life commitment. Jesus Lord. A police officer's determination depends on the elements of the statute. To determine whether there's probable cause to believe the social media post met the definition of the disorderly conduct, the court should look at 2 elements. Did she engage in violent, abusive, indecent, profane, boisterous, unreasonably loud, or otherwise disorderly conduct? No. And did her conduct occur under certain circumstances where conduct tends to cause or provoke a disturbance? No. Under both elements is a combination of conduct and circumstances crucial in applying the statute. At the time of Jackass Liar's arrival at the residence, he knew that Conrath had already been contacted by the health department regarding its concerns over the social media posts. In the post, she states she'd be infected with and ultimately beat COVID-19. According to the information by Conrath and Jackass Liar from the health department, Miss Cohoon actually tested negative for the disease. Jackass Liar was further informed that Amyiah's social media post was causing significant disturbance, anxiety, fear, concern, and even panic among citizens, especially because of Amyiah's recent attendance on a band trip with dozens of other students, faculty, staffs, and parent chaperones. As far as law enforcement understood Plam's post to be knowingly false, doesn't matter. And touching on an area of significant consequence of public health, the foregoing constitute at least probable cause for otherwise disorderly conduct. No, it really doesn't. As further evidence of otherwise disorderly conduct and disturbance in the community, the sheriff was advised by Nurse Davy, and we have an affidavit from her, but we're not going to get to that today. Yeah. Yeah, the lawyers are absolutely going to argue that she breached the peace, but that's not what that's referring to. When you're talking about breaching the peace, you're talking about, again, that the rationale for it is the immediate physical surrounding. It poses an immediate problem, right? The rationale is the immediacy and proximity of it, right? So like, it's not this. Thank you, Nuvi, for joining me. Your supportership is appreciated. Why are you not a supporter, Lint? Do you not love me, Lint? I thought you were a fan, Lint. What's your problem? Yeah. We banned Nightbot. You can't do asterisk anything anymore because we banned Nightbot. We banned Nightbot. Oh man. These citizens were understandably concerned about whether they had been exposed, whether they need to be treated or tested, and whether they need to miss work and potentially self-quarantine. The need to field the litany of telephone calls about Amyiah's panic-inducing social media posts by the health department and school district further pressed already strained report sources of the department. The information supported a reasonable belief that Amyiah engaged in otherwise disorderly conduct. The second element, I don't particularly have trouble believing that the public health authority knew of her test results, because like HIPAA is not like an absolute thing, like, especially for like certain things like this. Now, I'm not an expert on HIPAA, so please don't take anything I say as gospel, right? But HIPAA is like not absolute, specifically, particularly in like cases like, I would imagine, just off the cuff of my head, that there's some exceptions for reporting the police to the health department for like particularly serious ailments that have particularly contagious effects. So I'm just going to assume that this isn't covered by HIPAA, because again, I'm not expert on HIPAA, but like you would just anticipate that it probably has an exception for this kind of thing. So like, I don't have a particular hard time believing the health department knew of the negative test. What I do have a bit of a hard time believing is they didn't also know that doctors had like said, oh, we think this is COVID, even despite the negative test. Like that they only knew that one thing and didn't know other things. That's the thing that I'm like a little thrown by. That the health department only knew like part of the story. Yeah, no, like, yeah. Yeah, so like they wouldn't necessarily have to have a warrant if it's not covered by HIPAA, because again, I'm not an expert on HIPAA, but so yeah, I don't know exactly what the situation is, but HIPAA may not apply in this circumstance, if I had to guess. No one's mentioned HIPAA at this point, so I'm just going to imagine it doesn't apply in the circumstance. HIPAA is a complicated law with exceptions. Okay, where were we? All right. A court only needs to determine whether it's type of cause that to impose disturbance. Amyiah's post was the embodiment of the type of conduct that would tend to cause or provoke. I like what the attorney's doing. I like their try. It's not going to work, but it's going to try, right? Yeah. Well, it definitely wouldn't apply after she went public with her affection. That's for definitely sure. So yeah, it wouldn't apply. Well, no, because that doesn't work. Like if she had released her own medical records, then no. But just because I say, if I told you, I was diagnosed with whatever, even if it's true, it doesn't like suddenly make everything fair game. Like if I tell you I was diagnosed with a particular disease, and then you go to my doctor and say, well, is it true? My doctor's going to say, I can't tell you, unless HIPAA applies. So like, again, the issue isn't like, it's not just because she says it, something becomes fair game. That doesn't work. So there would have to be some other exception to HIPAA. If she released her own medical records, HIPAA would definitely not apply. But that's not what happened, as far as I know. The highly contagious novel coronavirus with which Amyiah publicly claimed to be affected had already resulted in the WHO's declaration of a public health emergency, declarations of public health emergency by multiple states, proclamation of national emergency, and closure of all schools in the state. As of March 23rd, positive cases in the United States had risen 119% in the previous 72 hours, and 5 Wisconsinites had already died. There was and still is no known cure or vaccine for COVID-19, except, maybe eating the sunlight, but we'll leave that for another day. I understand, by the way, what President Trump actually meant. That was more like just a joke on the media, incidentally, than anything else. Thank you, Heidi, for the support. It is super appreciated. Understandably, the public was being increasingly concerned with contracting the disease as demonstrated by the by the by the lots of concerned calls of the health department received as a result of the post. In light of these circumstances, it's difficult to imagine how an individual who law enforcement believes had falsely claimed to be affected after returning from a class trip with Myers would not be deemed to have engaged in conduct that tended to menace, disrupt, or destroy public order. Oh, I do like what they're doing there. Oh, that's a nice trick. That's a nice trick. That's a nice trick. You see what they're doing there? They're very, very subtly reframing it at the end there, because that's not the elements of the statute, right? That's not the elements of the statute, but I really like that. It's very, very clever, subtle shifting. And if you're not paying attention to what they're doing, you wouldn't notice it. But I like it from a lawyer's point of view. I admire it from a lawyer's point of view. They're very, very subtly moving the goalpost. Very subtly moving the goalpost, and they're doing a very good job of it. They say, how would this not deem to have engaged in conduct that menaces, disrupts, or destroys the public order? And you think to yourself, oh, of course it would. And then you just like, oh, of course they're right. But that's not the standard they have to reach, right? So they reframed the issue, and they did a very good job of it. Excellent job. Good job, counselor. Unfortunately, your client sucks. Thank you, Michael Pierce, for your contribution. It's super appreciated. $5 from Ricardo Ospina. Apologize. All I hear is a bunch of excuses why this violated her First Amendment rights. It's clearly unconstitutional per se. Well, I wouldn't go quite that far, Ricardo. I wouldn't go quite that far, but I do agree that it's unconstitutional. I agree this is some bullshit. But, there's definitely, there's a lot of problems, yeah. Both the potential effects and actual effects of defendant's conduct are probative in disorderly conduct. Sure. In this case, reaction to Amyiah's social media posts and the effects are also probative. Sure. In particular, Amyiah's classes, their parents, and other residents were stricken with fear, anxiety, and panic. A small sampling of community members impacted by social media have sworn declarations to this response. That's not what it's talking about. That's not what that particular statute is talking about. That's not what that is talking about. It's talking about something different. Now, there might be other statutes that apply, right? But that's not what they came with. They came with this specific statute and has specific context. So there might have been other statutes they could have used, in this, but not this one. I don't really see this working in the circumstance because the analogs don't apply, in the online context they do in the real world context. They don't really apply here. So there's probably other statutes that would apply, but not this one. So, the cops came and the cops are lazy. So I don't think this is going to work. The immunity piece, which was believed to be inaccurate, not only tended to cause, but did cause a disturbance in the community. But that's not what it's talking about. Therefore, defendants possess probable cause that Amyiah did engage in disorderly conduct prior to any interactions. As a result, the First Amendment claims fall as a matter of law. And then we get to our favorite section, guys. We've gotten to our favorite section, guys. It's time. It's time. It's time. It's time for our favorite thing here on. It's time for our favorite thing here on uncivil law. It's time for one of our favorite things. It's your favorite thing and mine. It's qualified immunity time. Let's talk about qualified immunity time. Okay, qualified immunity. And no, actually, and what's really sad about it is you and I both know that this has a pretty decent chance of working. Because we've covered enough qualified immunity cases on this channel, right? We've covered enough QI cases. We all know there's a pretty decent chance of this working. So a lot of this was crap. But there's a pretty decent chance the QI argument's going to work. And I say that in the view of potentially a judge. If I were a judge in this case, what would I do? Right? And as a good judge, I have to be bound by the rule of law just like everyone else. And so what I think should be and what I think is are two different things. So like what I think the law should be and what it is are problems. And I know too much about qualified immunity law that if you came to me with this as a judge, I'd at least be thinking about it. Because I know too much. So, the odds of a potential Justice Blackleaf, that'd be me, by the way, the odds of a potential Justice Blackleaf dismissing this on QI grounds are not zero. The fact that that's true depresses me. But, The law is the law, and we have to do what the law requires. So even if we disagree with it, so yeah, yeah. Thank you, Lint, for finally joining the club. It's about time. Thank you for the contribution. Yeah, you know, if I ever want to be a judge someday, I have to be a good judge, and it means I have to obey the rule of law. And I've said it before in a prior stream. One of the hallmarks of a good judge is that you reach decisions you don't want to reach. This would be one of those examples. Yeah. All right, let's read about QI. Summary judgment is appropriate because defendants are entitled to QI. Defendants could not reasonably have known their conduct violated the First Amendment rights. Under qualified immunity, government officials performing discretionary functions are immune from suit if their conduct could have reasonably been thought to be consistent with the rights they are alleged to have been violated. An official is entitled to immunity if, when he acted, he reasonably could have believed his action did not violate a clearly established law. Qualified immunity protects all but the plainly incompetent or but those who knowingly violate the law. Yeah, it's not looking super promising for Amyiah at this point. I'm sad, but yeah, this is the part of the exercise where we all become very, very sad. The Seventh Circuit instructs, although the privilege of qualified immunity is a defense, the plaintiff carries the burden of defeating it. Yeah, okay, yeah, because whether it's a defense or whether it's a immunity has been disputed. So they say it's a defense, but the plaintiff has to defeat it, which makes sense too. Either one's fine, whatever. In determining whether, if we're going to do this thing, that's fine. Either one's fine. In determining whether defense are entitled to qualified immunity, the trial court conducts a two-step inquiry, but it can start with either step. That's true. And it's usually true in multiple steps factors, right? Usually if you have like multiple steps and any step will dispose of the case, you can just jump anywhere. Like, if you have a multiple part test and you like one will dispose of it, you can just do it and be done. So yeah, you can go anywhere. It's fine. Sway Ocean asks, plainly incompetent. If attacking people's First Amendment rights is not clear incompetence, what is? Well, Sway, I don't know if you're asking that rhetorically or not. So I'll just say that, unfortunately, we've covered quite a lot of qualified immunity cases on this channel. It comes up quite a lot. And unfortunately, plainly incompetent, yeah, it requires a little bit more. A little bit more. It's depressing. Okay. In determining whether they're entitled to qualified immunity, the trial court conducts a two-step. First, the court must determine whether the disputed fact violates a constitutional right. Additionally, the court must determine whether it was clearly established, which is usually the element that this thing bails on. Whether the law was clearly established turns on objective legal reasonableness of the action, given contemporaneous legal rules. Thus, a government official is entitled to qualified immunity for unconstitutional conduct so long as there could be a reasonable, albeit mistaken, belief about the legality of his or her conduct. Yeah, we all knew it was coming. We all knew it was coming, guys. This is the bitter pill now time. This is a bitter pill. Yeah. Yeah. It is insufficient for the plaintiff to simply point out a recognized constitutional right and claim it's been violated. The Supreme Court instructs that clearly established inquiry must be undertaken in light of the specific context of this case, not as a broad general proposition. That language does a lot of weightlifting too, guys. Yeah, it must be established in light of the specific context, not in the broad general. And specific usually has to be pretty specific. The inquiry is narrow and assesses whether the right was specifically clear. A reasonable official would understand what he's doing that violates their rights. Yeah. In the context presented in this case, it's not clearly established the First Amendment retaliation claim is viable against law enforcement in absence of a direct threat to arrest. Further, considering that Amyiah, in the presence of her parents, consented to remove, she and her mother agreed to do so in response to a request, not a threat. It's not clearly established a law enforcement officer could face a First Amendment liability under the circumstances present in this case. $10 from Michael Pierce. Well played. I want to avoid discovery too. Yeah. I mean, it's A lawyer would be insane. A lawyer representing the police would be absolutely insane not to argue qualified immunity if it all comply. It would be complete dereliction of duty to not argue the case. So, like, we don't even know. I mean, we don't even know that this lawyer necessarily personally believes in it. I don't know anything about this lawyer. I don't know what this lawyer personally believes in. If you came to me and I took the case, I'd be writing this because I took the case. It's my job to represent you. I'm speaking for you, so I'm putting forward your best case. Of course, I'd write this. Of course, I'd write this. I'd be insane not to. So, what can you do? $2 for Johns Evans. QI should be allowed once. Reoffend, you lose it. We need to do something on QI, that's for sure. It's too broad for my taste. That's for damn sure. There's not clearly established the nature of the contact between Jackass Liar and Amyiah constituting an act of retaliation. A simple recitation of a citizen's First Amendment right does not define a First Amendment right in question with the requisite specificity. Further, as discussed above, the information provided to the Jackass Liar established probable cause to initiate contact with Amyiah. Such a reasonable officer in his position would not have believed requesting removal posed an adverse action that would deprive Amyiah of her First Amendment rights. Yeah, it's pretty good. We all knew it was coming. It's pretty good. Here it is not clearly established the nature of the contact between Jackass Liar and Amyiah amounts to a deprivation sufficient to deter First Amendment activity in a person of ordinary firmness. Plaintiff cannot cite to any authority clearly establishing the manner in which Jackass Liar interacted with Amyiah, violated her rights, and her allegations are simply not enough to establish a viable claim or defeat qualified immunity. The interactions with Jackass Liar and Amyiah were cordial. And far from even approaching the level of threat sufficient to chill speech of a person of ordinary firmness. There's no authority to establish this type of cordial and non-threatening conduct interaction amounted to deprivation sufficient to deter First Amendment activity in a person of ordinary firmness. As there's no authority that has established liability, Jackass Liar is entitled to qualified immunity. Sadly, probably true. Sadly, probably true. Sadly, probably true. The First Amendment protects the cherished rights of mind and spirit. There's no doubt the First Amendment rights of free speech and expression are fundamental and highly prized and need breathing space to survive. The First Amendment protects conduct, symbols, and nonverbal speech that attempt to express an idea or convey a message that will likely to be understood by a viewer. It even protects demonstrably false speech, as I've been saying many, many times. That's what I've been saying. Nevertheless, and this is the word that's going to kill our spirits, nevertheless, First Amendment protections are not absolute. That's true. Unprotected speech includes obscenity, defamation, fraud, incitement, and speech integral to criminal conduct. That is all true. In addition to the constitutional requirements described above, law enforcement also must attempt to reconcile the current realities in state law that in some cases may seem to conflict with this traditional appreciation of First Amendment freedoms. That's a colorable way to put it. It's a very colorable way to put it. Reconcile the current realities that in some cases may seem to conflict with our traditional appreciation of First Amendment law. That's a very, very nice shine on that particular turd pile there. The state laws. I do like that phrasing. I like that phrasing. It's a nice turd polishing job. Very well done. In light of the pandemic, local health departments, such as the Marquette County Public Health Department, are responsible for doing what's reasonable and necessary to prevention and suppression of disease, including taking actions that might otherwise be considered infringement of the First Amendment. Yeah. Authorizing departments to forbid public gatherings. Health department are responsible for disease, surveillance, contact tracing, and public outreach. So I think they're going to try to argue here the current situation gives them more latitude to restrict the speech than it would otherwise. Which, why not? Let's throw that in there. $2 from Hectic Gaming. Please see next post. With First Amendment claim, isn't clearly established without time, place, and manner, as the First Amendment is close to absolute as there is. With a First Amendment claim, isn't it clearly established without time, place, and manner law, as the First Amendment is closest absolute there is? Well, putting aside the First Amendment law, the qualified immunity law requires it to be a pretty specific fact pattern. The qualified immunity law is pretty generous to the police. It doesn't have to be exactly the same because, of course, that would never happen, but it has to be pretty damn close. And it has to be a lot closer than you're probably comfortable with, and a lot closer than I'm comfortable with, too. So, to find it to be clearly established in this particular fact pattern, it has to be pretty damn close. So, unfortunately, none of the cases Amyiah cited, and I'm telling you this as a matter of law, not as a matter of my opinion, because you can see the pain in my eyes, all right? None of the cases Amyiah cited are anywhere close to being close enough for qualified immunity purposes. Not even close. Not even close to close enough. I don't know what to tell you. I don't want it to be true. It's just the law. This is a legal education channel. I can't always tell you what you want to hear. I can't always tell you. I can't even tell myself what I want to hear sometimes. It is what it is. It requires something a lot closer than anything Amyiah has cited. Maybe she'll come back in her response with something a lot closer. So maybe she'll come back in her response with something a lot closer, so maybe there's something closer. But she doesn't have anything that's going to get her past clearly established right now. Yeah, it is what it is. Yeah. And they're going to claim that COVID, and even if she can find something, they're going to claim the COVID issue gets them past that too. The COVID factor is non-trivial here too. So even if she can find something, the COVID issue probably gives them another bite at the apple that they wouldn't otherwise have. I can see a judge leaping at it in a heartbeat. I can see myself writing it with very begrudgingly. I can see myself writing an opinion that dismisses Amyiah's claim on qualified immunity because even though there's a case that's as close as you would want under normal circumstances, because COVID, though, gives the government extra latitude, I can see myself writing that. I don't want to. I really don't want to. But, yeah, yeah. That's where we are. It's a shit show. The word unprecedented may seem ubiquitous in this current climate. To the point it's lost some of its meaning. Nevertheless, the present ongoing worldwide pandemic is indeed unprecedented. These are unique, extraordinary, and often frightening times in which reasonable fear may be stoked by the well-meaning gesture or statement. Given the upheaval, uncertainty, concern, and anxiety arising from everything pandemic-related, the health department asked the sheriff to assist in an effort to assist the public growing panic about the pandemic and possible cause of infection caused by the poth. To be clear, the health department did not ask for Amyiah to be arrested or for any sort of legal adverse action to be taken. Instead, the health department requested it to intervene to request the post be taken down, and that's exactly what occurred. Yeah, I hate my life. Yeah, I hate my life. John said, I think what they're trying to say is Stifle did not cover what they're trying to say because of word vomit, because the question was not raised about threat of arrest. Add the two. $2 from using the almighty COVID to stomp on rights. A little bit, Spartan. I'm not happy about it. But I am where I am. I'm not a happy camper. Do I seem like a happy camper? I am not. $1.99 from Jim Stellata. There's no disclaimer on the Bill of Rights for flu. What do you want from me? What do you want from me? I have to tell you what I think the law is as best as I can. I try to be fair, neutral, and objective and tell you what it is. And I think, yeah, no, it's not going well for Amyiah at this point. Under these circumstances, it's entirely reasonable for defendants to believe they are within their authority to carry out the request of the health department in order to ensure potentially dangerous misinformation would not be spread. It's also entirely reasonable for defendants to believe, even if ultimately incorrect, that falsely claiming COVID-19 is a modern day. Oh my God, I want to kill myself. Not really, guys. Don't panic. I was just a slip of the tongue because I'm depressed. Is the modern day equivalent to shouting fire in a crowd theater 100 years ago. Oh my God, help me. And therefore does not constitute protected speech. In light of specific, I want to burn my eyes out from reading that. In light of the specific and unprecedented context of this case, plaintiff can do nothing more than forward general propositions and point out a recognized constitutional right and claim the right has been violated. But this fails to demonstrate a reasonable official in position of the defendants would understand such a false claim would be protected, therefore they're entitled to qualified immunity. Yeah, I think they're right. I think they're right. We all knew it was coming. We all knew it was coming. And it has come. And I think they're right. Yeah. Yeah. The probable cause standard inherently allows for room for reasonable mistakes, but qualified immunity affords an extra layer of protection by shielding officers from suit if a reasonable officer could have believed the arrest to be lawful in light of the clearly established law and information that the officer possessed. Often termed arguable probable cause, qualified immunity protects officers who reasonably but mistakenly believe probable cause exists. Arguable probable cause also depends on the elements of the predicate offense. Arguable probable cause to arrest as an offense is all that is required. Beyond disorderly conduct, there was arguably probable cause for a violation of a different law, which prohibits using a computerized communication system to send out a message a reasonable person would interpret was sent to annoy or offend. Acting on belief that Amyiah knew that she was negative for the virus, and still posted it, would cause a reasonable officer to believe the post was done with intent to annoy or offend. Yeah. Even if the sheriff does not find actual probable cause, is least even if the court does not find actual probable cause, is least objectively reasonable for the sheriff and jackass liar to believe probable cause existed for either disorderly conduct or a violation of this other law. Yeah. The plaintiff has not named the county as a defendant, but she appears to make official capacity claims against them. Official capacity is tantamount to a claim against a government entity. For reasons below, plaintiff's official capacity claims should fail. As a threshold matter, we know this. We know about Monell. We know about all this crap, right? As a threshold matter, there can be no municipal liability or plaintiff fails to establish constitutional deprivation. In other words, where the court determines no basis for individual capacity, there's no need to address official capacity. As explained above, the First Amendment claims fail as a matter of law. Because they did not violate the First Amendment rights, there can be no municipal liability by official capacity, therefore summary judgment is appropriate. Probably. In general, to succeed on the official capacity claim, a plaintiff must demonstrate a policy or custom caused deprivation. Specifically, a plaintiff must establish the requisite culpability and requisite causation. Although she alleges she intended to sue Jackass Liar in his official capacity, the plaintiff does not allege that Jackass Liar has final policy-making authority. For that reason alone, the official capacity against fails as a matter of law and should be dismissed. That's wrong. That's wrong. That's wrong. But nice try. Plaintiff's sole official capacity claim is premised on a bald allegation that, as final policy-making authority, the sheriff represents policy for the purposes of liability. $5 from Robert gives me says, could a cop hog-tie a person for shouting? Robert. All right. Could a cop hog-tie a person for shouting fire and then leave them to burn if they didn't think it was a fire? QI. They didn't think there was a fire? I don't know. I'd have to think about it. But yeah, because that might be because I think you get under the excessive force analysis, And there's probably case law that deals with excessive force that would probably make that more well established. So, you wouldn't be arresting them for the First Amendment violation. You wouldn't be suing them for the First Amendment violation. You'd be suing them for the excess force violation. So I don't know that you'd have a First Amendment cause of action, but you'd have an excess force cause of action, because I think it's probably that's probably well established. So not First Amendment, but Fourth Amendment. So yeah, but at least you have something there. However, not every action taken by employees with decision-making authority gives rise to potential liability. The fact that a particular official, even policy-making official, has discretion exercised does not without more give rise to the function. In order to prevail in the official capacity premised on the policymaker's alleged decision, the plaintiff must show the policymakers responsible for establishing final policy with respect to the question made a deliberate choice to follow a course of action, which apparently they did, because we know from the police statement, right? In other words, the plaintiff must show the policymaker's act was in conformance with, creation with, government rules that have the effect of law. In kind, a policymaker's decision will rather have the force of policy unless the decision will govern similar issues in the future. Nice touch. So they're saying it's not policy because it was only a one-off. Okay. I'm not well educated enough to know whether or not that will fly, but it's an interesting argument. It's not policy because it's a one-off. But but then you would get basically into that they collaborated. So if it's not policy, it's that they were basically an accessory. So it wasn't policy, but it was because of the direction. I think either one works, but interesting idea. Neither the plaintiff's allegations nor evidence satisfies the elements for official capacity, policymaker Monell claims. The evidence is insufficient to support the theory. The sheriff spoke to Jackass Liar about the health department request, asked to be voluntarily willing. Jackass Liar went to the residence. After she was willing, she voluntarily complied. The sheriff specifically instructed Jackass Liar to contact him in the event that Amyiah did not voluntarily remove, so further decisions could be made, which is seeming like contemplation of arrest. 5 pounds from QI, the perfect tool in the internet age for undermining faith in the legal system. I don't know if it's an internet age thing, because QI existed well before the internet age, but it is a problem. It is a problem. However, because Amyiah consented to the Jackass's request, no additional decisions were made. Thus, because the Jackass Liar's encounter started and ended with the agreement, the sheriff was never faced with the deliberate choice to follow through a course of action. Not bad. I don't think that quite works. Because he even said to him that like they were thinking about it. So like the fact that they retain that like last bit of decision making authority. No, I don't think that quite works. It's a nice try, but it doesn't quite work. So it doesn't quite work for Monell. So I think you can get there under Monell. You're still going to have a damn problem with QI, so it doesn't matter. But yeah, you could get to the supervisor from Monell if you had a underlying thing, which you don't because of QI. But I think you can get to Monell. So yay. Plaintiff's official capacity claim against the sheriff amounts to nothing more than a cursory allegation the sheriff is a policymaking for the sheriff's department. He is. Like, who else would it be? The cursory allegation the sheriff is the policymaker for the sheriff's department? I'm just going to tell you that the sheriff is the policymaking authority for the sheriff's department. Yeah. Yeah, that's because it's called the sheriff's department. That's how you know the sheriff is the policymaking authority, because it's called the sheriff's department. Yeah. As lack of supporting evidence shows, the allegation effectively seeks to hold the county vicariously liable for the routine acts of the sheriff. That's not what they're trying to do. The circuit's laws routinely rejected such claims under Monell. Sign Samuel Hall, who definitely earned his fee. Attorneys for these peoples. He's done a very good job, and he's a very good lawyer. And I admire his work, and I still hate his clients, and I think they suck. All right, so let's read the brief in opposition to the motion for preliminary injunction and see if it teaches us anything more. Now that we've been so depressed from the summary judgment, which looks suspiciously like They're going to win. That was fun. So, yeah. 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 Defendants oppose the preliminary injunction. They base the entire argument on accurate versions of facts, mischaracterizing the actions. The critical allegations contained in sworn accusations are rebutted by the audiovisual recording of the incident, demonstrating she cannot meet the burden because she's actually threatened. Moreover, set forth in the brief for summary judgment, they have probable cause to believe it. $5 from Q Squared. Thank you, Q Squared, for your super chat. It is appreciated. That the cop got qualified immunity for sexual assault, as it wasn't as well established that you shouldn't sexually assault someone. This will be cake. Yeah, no, I mean, look, guys, we've done enough QI cases to see how well it goes. Okay, we've definitely seen a few QI cases where the court has denied it, but I unfortunately think that even if there's a case that is square enough on point that would normally get us past the issue of well established, even if there is a case that is close enough to get us past that, which by the way we haven't seen one, but maybe they'll come back with it. But even if there is one, but COVID though, I think is going to get them a lot further than any of us wish it would. I think but COVID though is going to get them quite a lot of latitude. Yeah, I think but COVID, though, is going to be pretty damn persuasive. And I say that because I'm looking at it as if I were the judge and looking at in the light of the relevant case law on these issues. And I think, unfortunately, that's the right decision under the case law. I'm not a happy man about it. I am not a happy man. But maybe the judge will surprise us all and pull a trick out of a hat and try to do something novel. That'll be fun. Christopher Sansell gives me $5 and says, big fan of your stream. Highly recommend. Is qualified immunity unlawful? A brutal original's take on QI from a paper. Thank you very much. I'll put it in my potential stories list. And my view on qualified immunity is it has gone too far. I think there is a problem it's trying to solve. That is a legitimate problem it's trying to solve. But I think it's just gone way off the reservation. Way off the reservation. And I think like how closely it has to be tailored, the well-established thing really pisses me off too. How close one case has to be to another case for the well-established is in the wrong place for me. I'd want to push it much further away. So, I've said before, and I'll say again, like if I were Supreme Court Justice Blackleaf, I don't know that I'm necessarily ready to end QI, although maybe that paper would convince me. So I don't know that I'm necessarily ready to end that. But I'd definitely be looking for ways to constrain it and put it in some sort of narrower box where it was meant to live. Because the reach of QI is so high that it's in the wrong place. We do actually have constitutional rights. They're actually important and actually matter and actually should have value. And when the government is violating those rights, it should mean something, right? The Constitution means something. It's meant to protect us from the government. But the QI standard is so tight that in a lot of these circumstances, and we're seeing it here, the government winds up violating your rights and there's nothing you can do about it. And that's crap. So, I think we need to figure out a way to solve the problem the QI is trying to solve in a more constrained way. And there are definitely people out there who want to just kill QI altogether. And I'm not saying I wouldn't do it. It's just not my first impulse. My first impulse is to look for a way to put this back into a box because it's trying to solve a legitimate problem. And I don't want to kill it and, bring about a problem if I don't have to. So I'd like to look for some way to put it back into a box that it's long since reached out of. So I like to look for something to try to figure out a way to do it in a way that puts it back somewhere if I could. But, I might kill it altogether depending on the day because it's really disturbing. It's a problem. Yeah, it's a problem. And A. Hedinger points out quite correctly, it's like, the other problem is if you get QI, how do you ever establish it? That is right. It's a very vicious circle. That's right, so it's like, Adam says, I like to look for unicorns. I don't think it's quite that bad, Adam, but your point is taken. Moreover, as set forth in the defendant's brief of summary judgment, the defendant had probable cause to believe Amyiah for citation. The existing probable cause is a bar. Preliminary judgment is extraordinary and drastic remedy. One should not be cleared by carrying persuasion. The purpose of preliminary injunction is to preserve status quo. The standard for injunction is relatively high. It's never a matter of right. There's no immediate threat here, so I'd probably be disinclined to grant the injunction as a preliminary injunction, right? If I actually got to the end of the case and a permanent injunction is a whole other thing. But as a preliminary injunction, there's nothing I'm trying to solve right now as a judge. So I'd probably be disinclined to grant the preliminary injunction. Not that she's going to win in the end anyway, but the case for the preliminary injunction is, the merits of it are much weaker. So there's a threshold phase and a balancing phase. The court determines it fails to establish any threshold, it must deny. If it passes the threshold, then it moves to balancing. In the threshold phase, the party must show that it has no adequate remedy at law and will suffer irreparable harm if preliminary injury is denied and some likelihood of success. There's no irreparable harm because there's no ongoing problem, right? Whatever occurred is in the past. So there's a preliminary injunction can only deal with future conduct. So there's no irreparable harm that's ongoing. That doesn't work. And so likelihood of success in the merits, as I said, is problematic at best. So yeah, I think the threshold phase fails. And also injunctions are considered an extraordinary remedy. They're not ever afforded as a matter of right. They're technically considered an equitable remedy, not a legal remedy. That's a very pedantic distinction that no one cares about except really pedantic lawyers. But yeah, it's it's an unusual remedy. So you wouldn't normally expect to see it, and I wouldn't do it here probably. This is an easier decision in terms of the case law. Because there's no ongoing problem. There's a remedy at the end of the day that will work. So the preliminary injunction is easier. In case where alleged First Amendment violations, the likelihood of success will also be a determinant factor. In balancing phase, the court raised irreparable harm. Without the preliminary injunction, against it would suffer, yes. In doing so, the courts apply the sliding scale, yes. And in the context of the First Amendment, some consideration of public interest is implicit in addressing the likelihood. Of course, the public has a strong interest in the vindication of individual rights. The interest is also implicated in protecting societal order and public health and safety. The character of every act depends on the circumstances. Because Amyiah cannot demonstrate likelihood of success, her motion fails. Further, if she could proceed, her motion fails because the balance of equities is not in her favor. So she's not likelihood to succeed in the merits. We discussed that in length and depressingly. The balance of equities weighs against it. The less likely they are to succeed, the more the balance of harms must weigh. Because they're not violated, she's not likely to suffer irreparable harm. There exists a substantial government interest in protecting the social order. Again, on a preliminary injunction standard, yeah. The low likelihood of success, high burden of showing, irreparable harm. While the loss of First Amendment freedoms is presumed to constitute irreparable injury, the court must balance that with the public's interest in permitting law enforcement to maintain order during the global pandemic. Yeah, again, but COVID though, and that's getting them some additional weight. Yeah, the but COVID though is getting them some additional weight. Seek to have this sergeant and attempt to produce it. Preliminary injunction must state its terms specifically. It's well settled. These provisions are mandatory, should be respected, blah, blah, blah. The request for injunction would not support a First Amendment interest because it seeks to prohibit action that did not happen in the past and is yet to occur in the future, making it possibly vague and speculative. It did not seek a specific relief. In other words, asked the court to prohibit the sheriff and the sergeant from engaging in acts the black letter constitutional law already prohibits requests amount to a request for immunity in the future. Specific hypothesized act that not only protect her as named action, but also her parents who are not plaintiffs. In short, such an order will protect Amyiah's social media speech with no more protection the law already affords, which fails to further protection interests in a meaningful way. Yeah, we similarly on page 13, Asked this court to enter a preliminary injunction prohibiting them from citing it for disorderly conduct first off. Again, this relief effectively seeks criminal immunity on behalf of named plaintiffs and non-plaintiffs for social media posts that have not yet happened. Ostensibly would be more nuanced than early Instagram posting. Yeah, as I said earlier, like when I was saying this in the initial briefing, like I would give you this, but I have to word it very carefully, and that's one of the reasons why. Like I'd have to word this very carefully to make sure the injunction was clear as to what it does and does not do because of these law enforcement interests. So I would go the other way, but it would have to be really clear. Jim gives me $1.09 size. The pleading says opens the statute up for challenge. Opens the statute up for challenge. Maybe. Yeah, maybe. So yeah, you could try that declaratory. So you could try this as a declaratory relief against the statute itself for the online speech in light of that other case. So yeah, maybe you lose this QI issue, so you can't get to the sheriffs, but you can sue the government in a different way for the declaratory relief that other case was talking about because of the threat here. Yeah, that's possible. I think that seems possible. So like maybe this will not survive against the sheriff, but maybe it will. Maybe it can be transformed into just a declaration, a declaratory relief relating to the speech itself. That might work. That's a good idea. So maybe we can get something out of this at the end of the day. Yeah. Yeah, you would sue the state and the municipality because apparently the municipality also has it on their books. So you could sue the state and the municipality for the law in light of this, in light of that declaratory case, that the case they cited dealing with the curfew and the threat of arrest and future application. Yeah. So I like that. There's a good idea there. That might work. Amyiah seeks to enjoin them for citing arrests for not only expressions that yet to exist, but speech that are different in substantive nature. For these reasons, the request is not only permissibly vague, it involves hypotheticals that are not on all fours with the facts of this case. The public interest would not benefit. In this vein, the request for injunctive relief seeking to enjoin the sheriff for subjecting them to criminal process did not enjoy. Thus, the placed in the foregoing, blah blah blah. Yeah. So like the preliminary injunction is pretty like there's no ongoing problem, and like so there's no real there's nothing really the preliminary enjoin. Right, so like, yeah, you wouldn't be able to get a preliminary injunction, I don't think. Preliminary injunctions are pretty unusual, because they occur so early in process. So courts tend to be a little bit more skittish of like a TRO or a preliminary injunction because they happen a lot earlier. So they're a little bit skittish, and rightfully so, because they happen very early in process. And so like they tend to be a little skittish of it. They're a lot less skittish of permanent injunctions. Like at the end of the case, they'll issue permanent injunctions without problem because you've had full briefing, full hearing. Everyone's had due process. But courts tend to be a little skittish of TROs and preliminary injunctions because both sides haven't had as much process. They haven't had full due process yet, so they tend to be pretty skittish of it. So, yeah, I wouldn't issue this TRO. I wouldn't issue this TRO. Or this preliminary injunction because there's nothing ongoing. There's nothing really for me to do here, so I wouldn't issue this TRO or preliminary injunction. So, yeah. All right, so let's do the declaration of the sergeant. Let's read what the sergeant had to actually say under oath. Let's read what he says about this. Let's read the declaration of the sergeant. Okay. I, Patrol Sergeant Clump, being sworn under oath, deposed and state as follows. I am Patrol Sergeant Clump. I have been employed with the Marquette Sheriff Department for 8 years. I based this declaration on personal knowledge and review of various documents, including reports and squad audio and video from the incident. On March the 27th, I was on duty as a patrol sergeant, working from 3 p.m. to 3 a.m. I was operating in a fully marked up squad car, which could add to the intimidation, which was equipped with audio and video. I reviewed this audio and video for the purposes of preparing this declaration. I did not, nor do I have the ability to modify the video and audio which was created. It is my understanding that this audio and video recording was uploaded and saved by the Marquette Sheriff's Department. They will be getting a fax from me on Monday, I guarantee you. On March the 27th, at approximately 6/21, I was advised by the Marquette County Dispatch Center to make contact with the sheriff about a complaint he wanted investigated. I made contact with the sheriff, who advised me he had been contacted by the health department regarding a social media post made by Miss Amyiah Cohoon. In this post, Amyiah stated she had beaten COVID-19, but by the Marquette County Health Department relayed she had tested negative. Since Amyiah had tested negative, I was informed the post was false and was causing community disturbance, unfounded concern, and panic with parents within the Westfield School District and others in the community, as Amyiah had recently been on a band trip with others in Westfield High School, students and chaperones, which include dozens of Marquette County residents. The sheriff did forward me a copy of the social media post made by Amyiah. Attached is Exhibit 3, a true and correct copy of the social media post, which incidentally is where I got it from, because it was attached as an exhibit. So that's where I got it from, because Amyiah didn't have it, but it was attached as an exhibit, so yay. The sheriff asked me to respond to the Cohoon residents, would make contact with the family, and to inquire whether they'd voluntarily remove the social media post that she had beaten it. I did discuss with the sheriff a variety of options for handling the situation if Amyiah refused to remove it. If Amyiah did not remove the post voluntarily, the plan was to contact the sheriff to discuss the situation before taking further action. On March 27th, at approximately 6:56, I arrived at the Cohoon residence located at the address provided. Yeah, I'm going to have to blur that out in the post afterwards because I've now unintentionally doxed a minor. That's just great news. My contact, please don't contact anyone, please, for love of God, who's not a public official, please, I beg you. My contact with the Cohoon family on March 27th was captured by my squad and video recording device, which has been preserved by the Sheriff's Department. This audio recording accurately portrays the law enforcement contact I had with the Cohoons on this time. The squad video portion of the recording device automatically records activity in front of the squad vehicle. Each deputy has the capability of turning on the mic pack, which is located on the deputy's shoulder or belt area. I turn on my mic audio shortly after I speak with Mr. Cohoon at his residence. So you can turn on the stuff and turn it off when you want to. That's great news. On this video recording, I'm wearing a Sheriff's Department uniform, and I remain outside the residence standing in front of the vehicle. While I cannot be seen on the video recording at all times based on where I'm standing, the statements I made, along with the conversation I had with all the parties, were captured on the audio. The recording depicts an adult male who I know to be the father, Amyiah's father. Her and her mother are also seen during various portions of the video recording. The video recording is 30 minutes long and also contains a date and running timestamp on the top portion of it. At approximately 6:58:27, I knocked on the front door of the residence, and a female who I know to be Amyiah answered it. I requested to speak to her father, who I also knew from prior contacts. Jim says, don't they have to surrender the recordings to the other side? I mean, surely, yes. It's part of the discovery, and it's already on the docket. They already submitted the USB with the recordings on the docket. It's on the docket, so yeah, of course they have to submit it. So it's part of the court record. I don't have it because it's on a USB, which doesn't do me any good, but it's on the court record. So yes, they have to surrender that. It's already on the court record. Yeah. The father came to the door and stepped outside to speak with me. Amyiah remained inside the home while I spoke with her father. I initially asked the father questions about the daughter, Amyiah, her school trip, and whether she thought she had the disease and whether she got tested. Her father began to explain Amyiah's hospital course and offered to show me copies of the records. He then stepped briefly inside their home, presumably to ask the mother to bring the records, and reemerged and indicated the mother would bring the records. At approximately 7:41, when the mother provided me with the records, I reviewed them. With providing these records by them, I never stated anything remotely similar to the allegation, stating that I stated I was not there just to complete the orders. The father described to me Amyiah's medical history over the course. This included information which confirmed that Amyiah had been tested for COVID. $5 from Nuvi. Thank you very much for your super chat. It is extremely appreciated. Thank you so much, everyone. Thank you so much, everyone, for your continued super chats. It really, really does mean a lot to me. I really, really appreciate it. It's a way to validate that I'm doing something that's valuable. I really appreciate it. I really appreciate every one of your contributions. I appreciate everyone who's joined a member. It really, really means a lot to me. Thank you so much. It does encourage me to keep going. It really does. Could she sue whoever told the officer F-face about her results of the corona test? I know they can in Utah, but they might be state law. Again, I don't know the specifics, and I don't know about the HIPAA and how it applies. But I'm assuming that because of the nature of the disease, there's some exception to HIPAA that allows and requires the hospital to report this to the health department, and the health department potentially to relay it to the officer. And again, even if not QI, but QY, but COVID gets you a long way in both of these discussions. But yeah, it doesn't strike me as immediately obvious that she has the ability to sue the health department for relaying that information, as part of it. Like the health department had the ability to get it from the hospital, and that the health department could tell them about it. Doesn't strike me as immediately obvious that's illegal. So that's probably illegal. I'm guessing, because I don't know health law that well, but I'm guessing it's probably okay. $2 from Nuvi. We love you too. Thank you so much, and thank you, Edame, for your support. It is very much appreciated. Thank you. I said, the lowest amount I could set membership to was $1.99 to be proper. It was the lowest amount I was allowed to set it to. And I set it to $1 because I just want people to be able to show appreciation without because I get when all these people are $5, it adds up a lot. Not to put too fine a point on it, but there was that girl on Twitch recently who was like, if you don't have $10, why are you watching this? Why are you watching Twitch? Give me $10. I'm an entitled blah, 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 blah. So, I definitely don't want to be that guy. So I set it at $1. So, it hopefully won't add up too much. So you can support me and other people, if you're so inclined. It's just a thing to, show a little love. So I appreciate it. $5 from A. Hedinger says, I would assume the parent offered to be show there, so there's no HIPAA violation there. Yeah, we weren't talking about that, though. We were talking about the part where the health department was relaying to the sheriff's department as part of the incident of the arrest. So, like, again, when the parent is showing the medical records to the sheriff, that's obviously not a HIPAA violation. That's obviously fine. We're talking about the part where the hospital reported it to the health department, or the health department reported it to the sheriff's department. Those are the two incidents we're interested in, and what the HIPAA laws are in those things. So things that Amyiah did or later did may or may not be relevant to that. And that's what we're interested in. And that's why I'm thinking I don't think HIPAA applies in these circumstances because of the nature of the thing. $5 from Vanessa Stotler. Thank you very much, Vanessa. It's super appreciated. Listening as I found this case interesting. $5 for bringing up the Twitch chick. Ha ha ha. Yeah, I want my if I should find it so I could just paraphrase it. I should find the exact quote so I could just redo it on camera. I understand that for some of you guys, like $20 is a lot of money, but it's $10. It's $10. And, that's, if you don't have $10, what are you doing watching this? Get a job. Why are you watching Twitch? You have $10. Don't tell me you don't have $10. Give me $10. Simps unite. Yeah. $2 from Heidi. Law and a glass of wine. A happy Saturday night. Fantastic. Glad to have you here. Tater. Oh man, you forgot to do the hand thing. I did get the gestures down perfectly. I'm sorry. I'll have to go back and rewatch it so I can do it again later. But that's as much as I remember. Yeah. Good times. Oh, man. Okay, Mr. Cohn described to me Miss Amyiah's medical history over the course of the week. This information includes $5 from A. Nev. Given your profession, could you be liable for slander of Sheriff Jackass? Absolutely not. My profession is absolutely not. And also, Jackass Liar is an opinion. It's opinion. Opinion is protected. Also, he's a government official, so that helps substantially. So, public figure and all that. So, no, absolutely not. Come at me, bro. Come at me, bro. Yeah, really. Yeah. Absolutely not. No. Good times. Describe me the medical history. This included, which had been confirmed by Amyiah, had been tested, and the test was negative. Approximately whatever. Mr. Cohn confirmed the test. He come back negative in the morning. Confirmed the negative test the second time. At approximately 7:02, for the first time, I explained the reason I was there. Why why are you talking to this random sheriff officer without him telling him why you're there? But okay, whatever. Hey, saying Dinger, how are you doing? Did you know you can now be a member of the Uncivil Law family? It's true. You can hit the join button and say Dinger, and you too can give me money. No, just kidding. I love you guys. Uh, Jan, I appreciate. Don't ever say who I work for. It's an issue of if I tell people who I work for, it's an issue of me having to give all kinds of disclaimers. So I appreciate you not mentioning who I work for. Thank you. It's not that I'm embarrassed about it. It's just literally if I ever mention it in any way, I have to give all kinds of disclaimers about how I don't speak for blah, 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 blah. So I never mention it because it's a total pain in the ass. So if I never mention it, I don't ever have to give the disclaimers. Anyways. Approximately, I relayed to Mr. and Mrs. Cohoon the post was causing many issues with the school district. I did show Mr. Cohoon the post had received from the email. I was under the belief the social media post made by Amyiah she was recovering was made on Facebook. I later was informed by Amyiah and her family she did not have Facebook, but the post actually made on the Instagram account. Can we have the disclaimers without mentioning it? You want disclaimers just for the hell of having disclaimers? Yeah, I guess. You know. The opinions in this video do not necessarily reflect the views of the United States government or any of its agencies. Yeah. They most decidedly do not necessarily reflect the views of the United States or any of its agencies. At approximately 7:07, Amyiah stepped out for the residence the first time. I explained to the Cohoon family I was there to figure out what the post was about, saying Amyiah tested negatively and see if the post would be taken down. At approximately 7:07, in response to the statement, Amyiah immediately responded by saying, I'll do it. I took Amayiah's statements to be a voluntarily willingness to delete an Instagram post. Law licenses may or may not be public. My one in Virginia is not on the public database because in Virginia you can choose whether or not to be on the public database or not. So I do have a Virginia law license, but if you like typed my name or typed my number, it wouldn't show up. It's not in the public database because you can choose to restrict it. So I choose to restrict it just so I'm not in the database. I don't know whether or not you FOIA'd Virginia and asked for my law license, whether they give it or not. Presumably, yes, it is a government record. So, like, if you really want to FOIA the state of Virginia and get a copy of my law license, go nuts. $10 from a collector. I thought CDC said all cases in question marks to be marked as plus. That means the test is not reliable and post could be correct. Yeah, no. And she was also told in the work release form that it was COVID or thought to be COVID. So, it's a thing. It's like, so yeah. Oh, I am in Texas. I don't have a Texas law license though. I only have one in Virginia. I'm working on my Texas paperwork. I only moved to Texas a month and a half ago, so I don't have a Texas law license yet. I have a Virginia license, and I also am a patent lawyer with a patent bar number, which means that if I wanted to practice patent law, I could do so even in Texas because it's a federal license. So there's that too. But I don't have a Texas bar membership yet. I'm working on it. At approximately 7, I probably will just wind up sitting for the bar again in February, to be quite honest. Yeah. Yeah. I I have a Virginia bar license, and in case you're interested, I also have a license before the United States Patent and Trademark Office as a patent attorney. I'm also admitted to practice before the Court of Appeals for the Federal Circuit, and I'm also admitted to practice before the United States Supreme Court. So those are my admissions, in case you're interested. So if you would like to FOIA any of the bodies I just named and ask them for a copy of my law license, I don't know. Go nuts. Sure. Uh, Amyiah's father seemed upset with the medical process and inconsistencies. After additional conversations with Amyiah about the course this prior week, at approximately 7:10, I stated, nonetheless, can we get the post taken down? $5 from Q Squared said, a-hole cop, but she'd leave voluntarily. Sure. But not well established, but co-ed. But I don't record my audio when I make threats. Come at me, bro. I know. It's a whole pain of things. Have you ever brought anything to a party, Scottus? No. I've never been a party to anything at the Supreme Court, nor have I ever brought anything. But it does entitle me to get special seating at the Supreme Court, which is cool because I was there when they announced the Obamacare decision. I was there in person when they announced that. And the only reason I was there in person because it was very, very popular to be there. The only reason I was able to be there in person was because you get special seating as a Supreme Court bar member. So you get to sit in like the first couple rows. I was pretty damn close to the justices when they announced that decision. It was pretty damn cool. So that's one of the perks of being a Supreme Court bar member is the seating. Also, it looks cool in the resume. $2 from Ricardo Ospinilla. Why do people please assume that HIPAA covers the government? Well, yeah, I mean, yeah, it does or does not cover various stuff, but it's a problem, yeah. I've never made an oral argument in front of the Supreme Court. I would kill to make a Supreme Court argument. I've been there in person with them, made arguments. I was there in person when they argued both Heller and McDonald. That was pretty cool. I was there in person when they argued Heller and McDonald. That was pretty damn cool. So I was there for that. I was there for when they announced the Obamacare decisions. That was pretty cool. That's one of the perks of living in DC. So that's kind of cool. Please don't stalk me. Please don't stalk me. That would be not cool. There. Up until the point Amyiah twice took an agreement, she removed the post. I never suggested, insinuated, or threatened anyone could face arrest. At approximately 7:10, Amyiah then walked inside the residence, outside my presence, and closed the door behind her. While Amyiah was outside my presence, and after Amyiah had already twice indicated she removed the post, at approximately 7:10, I did state to Mr. Cohoon, Richard, I don't want this to go this far. It was simple as me coming out here and just getting the post taken down and walking away. After Amyiah agreed to take down the post, and while Amyiah was inside her home, presumably take down the post, I did tell Mr. Cohoon the potential for disorderly conduct due to the fact the post was causing a disturbance in the public by posting her daughter was positive and other people were upset. Yes, I can go pro se and argue my case in front of the Supreme Court. I can do that. If I ever get a case in front of the Supreme Court, I could argue it pro se. They actually amended the rules a couple years back. To say that pro ses couldn't argue their cases in front of the U.S. Supreme Court, but there is an exception. If you're a member of the bar, you can. So yes, I could argue a pro se. You can't argue a pro se in front of the Supreme Court, but I could. So that'd be cool. Yeah, I'd do it. I'd totally do it too. I'd totally do it. Totally do it. While I made statements about potential for disorderly conduct, this was after Amyiah had twice agreed to remove the social media post. In addition, when I made these statements, I was rather inside the home. I did not have plans to immediately issue citations or make referrals for disorderly conduct. Even Amyiah would not have agreed. Sure you did. I previously discussed with the sheriff that there was a wide range of options for Amyiah refused to voluntarily remove it. While its potential included disorderly conduct, it also included with working with the county's health department to take other actions or potentially contacting Facebook. Again, at the point of my discussion, we both believe this to be a Facebook post. Okay, well, you don't know what Instagram is, so that's good news. If Amyiah Cohoon refused to take the post down, I'd further evaluate the situation, discuss the situation with the sheriff before proceeding with any options, including the issuance of permits. Yeah. Well, there's a couple answers to your equal protection issue before the Supreme Court. One, it's the Supreme Court. So who are you going to complain about the lack of equal protection to? So there's that. And two, it's also just an issue of you're run-of-the-mill pro se. It would not go well. The Supreme Court is looking at very technical legal issues, and they're trying to do it for a whole rest of cases. So yeah, they won't do it. But, they will, if you ever get to the Supreme Court as a pro se, they will appoint you a lawyer, and you'll have a very good lawyer, and they'll work for free. And it's considered an honor. So they're not going to appoint like a garbage person. They're going to appoint someone who's really good. And it's considered quite an honor, as you might imagine. And this person's going to do a better job than you could ever hope to do. So there's that. But yeah, it's, it's the Supreme Court. It's discretionary review. You're not entitled to the Supreme Court as a matter of right. So they come with their own rules. What do you want? It's the Supreme Court. Deal. Instagram is owned by Facebook. Guess why they put it like that? I guess that's what it is. At approximately 7:18, I asked Cohoon if she could bring the phone to show the post was removed. Like a good fascist, I was making sure. Cohoon agreed to enter the residence and approximately yelled for Amyiah within the home. After yelling for Amyiah, stood to open the door to return approximately 15 seconds later. Mr. Cohoon reemerged from the residence at 7:18 and stated the post was not there anymore. It did not show up on my phone. I got the impression Mr. Cohoon had believed and expected the post was already removed, but suggested to me that I looked at the phone. I explained to Mr. Cohoon that I'd only seen a screenshot of the post, then appeared to obtain the phone to check to verify the post was removed. At 7:18, Mr. Cohoon stated to me, I kind of understand where you're coming from. Like I said, we're failing to understand each other. At 7:18, Mrs. Cohoon, Amyiah reemerged from the house with the phone. Amyiah reported to me social media had been taken down. Amyiah proceeded to show me the phone, showing the post had been deleted. Sounds a little bit like Mr. Cohoon had been a little bit vague here, a little bit not on the ball here. Yeah. At approximately 7:19, Amyiah told me I appreciate the post. She responded, of course. No time to ever state or threaten Amyiah that she not to take the post. I would not arrest her or disorder. In fact, I never made any threats or suggestions in her presence or suggested the arrest. I never told Amyiah she did not remove the post. I had direct orders to issue citations to take people to jail. In no time did Amyiah apologize. No point did Amyiah did Mr. Cohoon bring Amyiah outside to explain she did not have to delete her post, that she would not delete her post, but she could decide. While I showed Amyiah a screenshot and never told her she did not remove it, I had issued citations. All my interactions were professional and neither raised my voice nor ever threatened with arrest. It's my intention to speak with Amyiah to explain the negative impact it was having and hope she voluntarily remove it. I have significant concerns over the social media post, which is already called unfounded concern, disturbance and panics with parents, students, health department, and other county residents, and will continue to cause further panic. Pursuant to law, I certify this as true under the penalty of perjury. Signed, the guy. Okay, well, that is enough for our coverage for today. But we will definitely be doing more. We will probably be doing the affidavits of the other people because there are quite a few other affidavits. If there's a response from Amyiah's lawyer, we will definitely for sure be covering that. And I will file a request with the sheriff's office, see if I can get a copy of the transcript or whatever from this video. That'd be nice. Can I get a copy of the audio, a copy of the video, or a transcript? And could you send it to me via email, or figure out a way for them to send it to me or something. That'd be good. I mean, they won't be able to figure out Google Drive, but I'd send them a link or something. I don't know. Can you send me a copy of it? Would be nice. So I'll send them a fax on Monday and see what I can do in terms of getting a copy of this thing, because that'd be cool. Yeah. We could MST 3000 the video. What is MST 3000? What is MST 3000 the video? Oh, Mystery Science Theater. Okay, sorry. I got it. I'm on board. Apologize. I'm there. I figured it out. Yeah, I figured it out. All right. So yeah, there is a lot of time that's lost in transcription. That's true. But I'll take something rather than nothing. So I'll ask for what I can get and see what I can get. And say, can I please have this? If you need a formal FOIA, let me know. I'm willing to pay fees, blah, blah, blah. Let me know. So we'll see what I can do. I'll send them a fax. Yeah. It is like a React show, yes. Yes, it is like a React show. So yeah, I'm sure that their state law has a FOIA equivalent. So I'm sure that does. I'll look it up. Yeah. So I'll look it up. If you liked this stream, for the 153 of you who are here and 110 likes, that may be a record. I don't know that I've ever had that many continuous viewers and that many likes for a live stream. We did pretty good. And we actually did pretty good on Super Chats today, too. That's really encouraging. So thank you, guys. I really appreciate it. I really genuinely do. It's validating to me to be able to teach. This serves two purposes for me. I get to learn and I get to teach. So I can read a case learn what it says and teach it on the fly because I have enough background information to be able to do that, right? Because I understand a lot of other stuff. So I can read a case, understand what it's telling me, and relate it back to you in real time. But so I get to learn something and I get to teach you about it, which is really, really fun. And I've said before, I don't know if I've ever said it on this channel explicitly. I've said it before in like other contexts, but I've said that I think the academy is wherever people want to learn, and that's as much online as anywhere else. And so, like, I have 141 people watching this and listening. I never have a law school with 141 people in this, so I was like, this is like very validating for me. Yeah, $2 from the Spartan checks. Yay for the record. We'll enjoy learning from you. Well, thank you. And I like to think I'm getting better. I like to think I'm improving. I like to think my technique is improving. I like to think my diction is improving. You know, we made the very thoughtful addition of making the background a little less white. So we changed the color for you guys so it'd be a little bit easier to read. We're trying to make progress here. So, we really appreciate it, and it's very, very validating. And we've got 6,500 subscribers, so 7,000 is not too far behind. And if Google will ever respond to me, we can start promoting the channel. That'd be good news. Of course, no one's can respond to anyone anywhere because everyone's COVID. So yeah, my unfortunate prediction for this is the QI is going to be a total killer. It's going to be a total killer. It's going to be a complete killer. None of the case law is anywhere close enough. Even if they come back with case law, it's closer. But COVID, though, is going to get them a long way. So I think that as much as I do not want it to be true, I think that Amyiah has some serious problems. I think Amyiah has some serious problems with it as it is. So it's shitty. It's shitty, but it was. Badges. Use an icon with different color backgrounds. I mean, I can for the badge. I mean, I can select like any badges I want. I'm just using the default YouTube badges now because I put literally no effort into it, which is also another reason that they're 99 cents memberships. The only thing it tells you to right now is like the batch recording streams that I do. That's part of the deal. And like I did one 4 hours today that was just kind of for fun, so I made that members only. This one is going to be public. This won't be members only. But sort of the batch recording streams. But until I figure out like better benefits or something, it's like I'll just use the default ones. But if anyone has ideas for icons or something or membership badges, that's cool. Let me know. You know where to find me. $2 from Robert Saz. Please get some HD matting power from Krylon. Okay, cool. Will do. I'm all about that. I am all about that. Very cool. I will be happy to do that. That's very cool. Thank you very much. I appreciate the suggestion. I will do that. Very cool, Robert. Thank you. So, thank you very much for your contribution. How do you become a member? There's a little join button. Hopefully, there's a little join icon on your screen if you're on desktop. I don't think it's on mobile. I don't know if it's on mobile or not, but there should be a little join button of some kind. And if you click the little join button, it will ask you to give me $1. And if you say $1, then, you'll become a member and you can be a cool kid. Yeah. So, yeah. But I appreciate it as always. Appreciate everything. Until later, my friends. I will talk to you later. Cheers and goodbye.